What's up? Good morning, good afternoon, or good evening, depending on where you're at in the world. I am Bob Mata, and this is Defense Diaries Podcast. Welcome, 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 beautiful humans, to day two of the second week of March as we plow towards trial in the Karen Reed case. Ton of filings today, massive amount of filings today. I'm going to try to kill some time while my better half, my much, much better half, gets her shit right and gets on the screen. So that'll be, she asked me to kill some time. Oh, see, it's only been a couple minutes and I dropped my first expletive. So expletive, sorry, not explicative. Beautiful day in sunny Illinois. Say it's about 55. Good day for walking the dog, playing catch with your kid, or sitting on the YouTubes talking with your homies, which is you guys. So happy to do it. Happy to do it. I'll make a couple of announcements. As you may or may not know, I have Tony Bruschi of the Hidden Killers podcast will be joining me tonight at 7 p.m. Central Standard Time, which is where I'm at. So do your mathing accordingly, either east, west, whatever the case may be. But 7 o'clock, Tony Bruschi. I have not, like, Tony and I talk about everything. Like, I do a weekly itch. We're so glad that you're here. And thank you for your generosity. I love that. Thank you, Itch. Throw that right up there. Give you some love. Thank you for that early love in the live. Always gets my spirits up. Because, I'm nothing if not a grifter. Boop. So I think Tony's going to be a great conversation. Like him and I, because he does his thing and he puts it on a weekly podcast of his main podcast, which is Hidden Killers. He's got 1 million. See, I exaggerated and used 1 million. Like I was talking about last night during the live. He's probably got 50 or 60 different podcasts. This dude pumps them out. He's like a machine. So he is, 71 here. And I now know, Susan, it's Reading. I know that. I did historically for my entirety of my childhood while playing Monopoly and dominating. I'll have you know. I always called it Reading Railroad because that's how it reads. So by the way, I messaged Aiden and I'm like, yo, dude, sorry I was butchering your name during the first half of my life. He's like, oh man, he's like, dude, don't worry about it. It happens all the time. So there you go. I went right to the source. Told him, hey man, my fault, bro. Didn't mean to do that. I mean, the other alternative is you could maybe pronounce your name the way it's spelled. How about them apples? You like apples? All right. So tonight, Tony's going to be on. My point is that we always have great conversations. We get into the weeds. He knows everything about just about every case that's going on. He's big into Reed. He's big into Koberger. He's big into Richard Allen. And I always appreciate his thoughts. He's a very thoughtful guy. And we have a lot of fun together. So I'm hoping that's going to be a great live. And then tomorrow, the one and only Anjanette Levy. I don't know if I'm going to have to ask her. She might go by Levy. I think she might go Anjanette Levy. I'm going to ask her for certain. I think it is Levy, Anjanette Levy. I mean, you've got Eugene Levy and his son, I think is Daniel Levy, right? And then you've got Levy. Why are you cricketing me, girl? I'm just killing time. Girl. But so she's joining us. If you don't know anything about Anjanette Levy, thank you, Julie Frew. She is fabulous in a lot of different ways. Like I was saying yesterday, I didn't realize the first time I watched Making of a Murderer that that was Anjanette, that the one was really, really giving the business to Dean Strang and his other lawyer. What's his name? Jerry. Jerry, I think is his other lawyer's name. Yeah, Jerry, maybe. I don't know. So at any rate, I didn't realize at the time till years and years later that that was Ann Jeanette in that particular documentary that was just giving them the business. So I was like, wow, she is like a reporter, you know. So and then she covered another huge case, which we'll get into all that. She's big into Kohlberger. So I think oh, did you see that when I was muted right away? On hey, look, Joel, he's as much of a tech wizard as I am. I'll tell you that right now. Which is we're both wizards, like wizard level wizards, like master level wizards. That's how Joel and I were with tech. Making a murderer, yeah. Sorry there, Mandy. But yeah, she's amazing. So we're gonna get into a lot of Kohlberger with her. That's really kind of her bread and butter right now. Uh, thank you. Thank you. I appreciate that, Anja. It's very, very nice of you to say. I always have fun with Joel over there. And we had a great panel last night. I always have a blast over there. Joel's a lot like me. He's sensitive about things. He takes things to heart when he sees people talking shit in the chat. You know, he's like, well, you know, I can only be me. And you know, it's like I want to be genuine. I'm like, yeah, of course. You can't let you know, people bully you from being you, bro. Kidding me? Don't even worry about it. See, I'm a lawyer and taking beatings as a defense attorney. Oh, there she is, my beautiful and brilliant co-host. I have not done the
Official,
official
right.
opening yet. I'm
Did
just
you let the people know? So, just so you guys know, if Bob hasn't told you, he's like, "Well, I'm starting with," and it's the video, if Bob hasn't mentioned it, of this, BR Trouble 31 or
BN
BN
trouble. Yeah.
Trouble 31, that I saw this morning and, like, sent to Bob, and then I'm like I sent it to Melanie, she's like, "Yeah, I saw that," like, so everybody was on it. And he's like, "I'm gonna start with that," and I'm like, have you reached out to the guy yet? Like, did we get approval for that?" So, we've tried as of, like, a couple minutes ago. I don't know that they will,
It's
um
really hard to get a hold of people via YouTube unless they supply their email kind of like in their bio or even in the description of the show. Um, it is very, very difficult to find them. I couldn't find them. Allie tried to find them on Twitter, which was a hilarious story. Um,
Thanks, Itch. We're excited to be here.
I already threw that up and
Oh,
thanked Itch.
alright.
But I'll tell you what, it's the fact remains. We are thrilled that she's here and we're thrilled with her generosity. Both of those things.
Yes, yes.
So yeah,
I don't
and
know,
we'll
I was like, he's probably on Facebook or Instagram, both of which you can pick up the phone and call. I would have found him yet. If I had known, like, 5 minutes earlier, I'd have all his business, but,
I mean, if you don't know his actual name,
um,
like how you getting his actual business when you don't know dude's
well,
name?
because it's
You gonna
that's
go
his,
on his
like, handle in some
be
things.
in trouble on his LinkedIn? Is that what
Uh,
you're gonna do?
you can find people. And be
Maybe.
in trouble 31, no one else is using that. He's probably used it elsewhere, and
Listen,
that's
I
where you
mean,
start.
I'm gonna put the diggers that hang with us in this crew up with any diggers out there. So, you know, I mean, if you guys want to accept the challenge to find out who BN, and that's B as in boy, N as in Nancy, trouble 31 is, see, Mandy already called his mom, and his mom said he's grounded for making that video. So, like the entire point here is I did tell Allie, I'm like, look, we're going to start with that video because
He's
it's
on Reddit, unless that's something somebody started today. No, it looks like a while ago. So there's that.
because
Um,
our policy is that we're not going to show other people's content unless they've agreed to it. So, there goes me showing that video first because he's been non-responsive. Because I popped up in the chat of that video and was like, "Hey, man, that was top notch." But Aiden did too. He's like, "I want to use it on tonight's live," and
When I went to
he
ask,
didn't
I
even
saw
get Aiden
Aiden had
up.
asked,
Right.
and they may have
I mean, the
figured
guy
out,
might have an actual job. Like, he might not be able to sit around all day
or
on
he might not
YouTube.
know that everybody's going crazy about this right now.
Yes. Yes.
So I don't know if anybody out there wants to try on Reddit, but I don't know. I think you could probably figure out the last time someone's been on there. But yeah, it does. I'm not finding much else, at least with limited sources such as starting. I'm just seeing his name come up as people posting on Facebook about the video, people posting on X about the video, and then that username has a Reddit username, and an avatar under protouring.com, which is car related. So I guarantee you that's him. Um, but it's from 2015. So,
Yeah, he did sound like a car guy a little bit, you know?
oh yeah, all of his YouTube videos are car related.
Ah, he had those mechanics' hands. I'm serious. It's like mechanics, they have like can never all the way get the oil and the grease out of your hands, like as hard as they try. It's just kind of like after years of working on cars. It's like my uncle was a service writer for Cadillac. My cousin Jimmy obviously owns Deese. Deese. How you doing? I'm Deese. Like that, Deese. Deese Auto Body, Auto Shop. So I've got mechanics up in my family, and they can never
Hmm,
get their hands clean, not even
hmm.
with the goop. I
Up,
use the
got a
goop.
profile. Got a profile.
We're
Damn it!
we're
I need to have an account to see the profile. I
we're
don't have
zoning
permission.
in. We're
I don't have
zoning in.
permission to access his profile.
I mean, so Megan, also known as the Spitfire Dragon.
But again, this is
It's a great
2015.
video. He basically was able to get his hands on uh the entire mounting, I guess, whatever. What would you call that? The
Well, why don't you do
entire
the intro and then we'll describe the video and tell our viewers/listeners to go to his YouTube. Um,
Okay, so just to finish up our pre-show kind of announcements. Tonight, Tony Bruschi, 7 p.m. Tomorrow, Anjanette Levy at 5:15 Central. She's like, it has to be after 6:15. She's East Coast. So I'm like, all right, cool. 5:15. Because remember, I'm trying to stick to the schedule so that you guys know when we're on, like on a daily. So it's like it's Monday,
you'll never know.
Wednesdays. I am though. I
No,
really
they'll never know because who
it
knows what could
will, because it's
happen.
gonna become a habit. It's Monday
I'm
and
just saying.
Wednesdays are at 5, Tuesdays and
Mhm.
Thursdays at 7, and then Felonious Fridays.
And
Well,
what
I'm
if
always
something
gonna
drops like right now
till we
on
go,
Richard Allen?
till we go, till we out, or we just get the document and we turn this into that. I mean, I like that's the thing. Like if things are popping, we're like the updating stuff is never gonna change. Like if we have to go live, we have to go live.
All right, I gotta
So
grab water and then we can do the
I would
official.
say so. Coffee, my coffee
Yeah.
face. So and then Thursday, I've got the one and only, the fabulous, the brilliant Joshua Schiffer, who is
Water.
really, really smart and really, really funny. And I'm also bringing on my buddy Rich Schoenstein, who's another brilliant lawyer, does a ton of stuff back in the day when they used to have talking heads such as myself on Law and Crime. That's when I met Rich back over there. Really bright guy and a real straight shooter. Like Rich doesn't play games. Like Rich, he doesn't take sides. He's not in on the grift. He's not worried about like pissing one side or the other off, which I love. Which I love because I'm the same way. For as much as people think that I'm always picking sides, I'm like, I'm picking sides because I feel that way, not because of other way or because other people feel that way. I mean, if other people feel that way, that's awesome. if people agree with me that Richard Allen's due process was absolutely shat upon, that's awesome because you know what? It was. So, like I never bend to the will. I just don't do it. I don't bend the knee to anybody. I don't bend to the will. I'm certainly not a paid shill for anybody, I'll tell you that.
You're a paid
So,
shill,
Julie, you
an
ain't never
unpaid
lied.
shill.
Yeah, unpaid shill. Julie Frew, we do have
Right, so we gotta
100,000
get to
motions.
it. So let's do the official intro.
Okay, you
Wait,
ready?
wait, wait, we gotta thank some people before.
Go ahead.
Um, oh, well, Anne said the Taillight housing. Yes, we're gonna get to that. And thank you, civil rights investigator, for your generosity. Yes, his Reddit's 4 years old, no posts, 1 comment. See, he was on it or
And for
she
your
was on it. I'm gonna go
investigation.
with she, civil rights investigator.
Are you doing some kind of stereotyping?
I just think women are better at everything, so I'm gonna default to a woman.
I I do not disagree with that. I'm very much on board that women are much, much smarter than men. So, and I will die on that hill. Sorry, guys. Don't be mad at me. It's the truth. Okay. So, all right, you ready? Let's go.
Okay.
All right. Let me clear my throat. Let me clear my throat.
And let me thank Nikki for her generosity. If
Love
this is taillight stuff is actually news to the defense, is it too late for them to get an expert for it? I'm gonna answer that as soon as we go here. So I'm gonna leave it right up there so I can do that.
Okay, you ready?
No, I'm just kidding. Yeah.
She's ready. All right. Hello and welcome to the docket presented by Defense Diaries. I am your host, Bob Mata. And as always, I am joined by my beautiful and brilliant co host, Allie. What's up, girl?
Hey babe. Hey all.
So, we are going to continue our coverage into the unbelievably insane Karen Reed case, which is closing in on trial number 2 after just a wacky trial number 1. And this pretrial period has left nothing to be desired. It has been a battle to the death between two sides. They've got a new special prosecutor, Hank Brennan, and he's trying the case in the stead of Adam Lally. And you've got the normal team with Alan Jackson, David Yannetti, Liza Little, and the new and my favorite addition to the team, the great Bob Alisi. So today I have a feeling, honey, that there was a deadline, a filing deadline, because we got a flood of motions in limine that came in. And I'm going to defer to you because you are the boss. And just so you guys know out there, about 4 years ago, I hunted the earth for a necklace that just said boss. And I bought it for my wife. And it's amazing. And it's true. And she doesn't wear it anymore. Heartbroken.
And just to respond, I do wear it. It's huge. I can't wear it all the time, so it's, special occasions, like, kinda wear it. It's not an so he gets upset because I wear the little one my kids got me that says "badass," and that I wear every day. I'll wear it to court, it's tiny, sometimes people notice it, sometimes they don't. Um, it's an everyday necklace. But in any event, you were saying, "I'm the boss," so what? What were you about to
How do
follow
you
that up with?
there are, in fact, 1,000,000 pleadings. So how do you wanna do this? You said you thought it might be most helpful to go through the affidavits. Here's the challenge. So
Well, wait,
Tracy.
before you get to that, let's tell the people what came out on YouTube today, and you'll have to go to YouTube. The YouTube channel is BN Trouble 31. And what this YouTuber did was he got the exact taillight and housing taillight of Karen Reed's car. And he proceeded to damage it. So part of the point of the video is to show how hard it is to damage it and what force you need to damage it. And he used, was that a hammer or it was
The hammer.
a hammer? But what was of most importance to Bob and I, what like shocked me And where I'm mouth open, jaw dropped, is that what he established was the illumination of the light, what the light looks illuminated in different phases of damage. And with the red tail light missing, the light still reflects red. It is not a white light.
Or
That's first of all.
amber. It's like red or amber.
It's got
Whatever the case may be, it ain't white.
right. It has red to it.
Yeah.
And what was also extremely compelling was that there was the white piece of plastic. And this, I think the state might have called during trial that it had bubbles, it had tiny little holes. And those of you might recall, it was what Lally alluded to was the what caused the scratches on Officer John O'Keefe's arm, these little perforations in the clear piece of plastic. I specifically remember that. However, when that clear piece of plastic is removed, is off of the taillight housing, the light doesn't light up at all. There is no light except for two little spots of red. That was most assuredly red, the two little spots at the top where the bulb itself is. So this was extremely compelling to say whatever condition the taillight was in the videos that Brennan was showing during the motions to dismiss, where his argument was, Your Honor, we know there was no tampering. We know that this was the condition of the taillight. Look at the white shining through before it ever makes its way to the sally port. Well, this establishes that that's not what it would look like. If the taillight looked and was in the condition it was, once it got to the sally port, or so they claim, it would not have illuminated white. Right, babe?
It wouldn't have illuminated at all. When he took the large piece off, the only two things that illuminated were those two little areas up at it is, look, the guy obviously is a mechanic or he does work with cars. Maybe he's got a body shop. I don't know. He's clearly not an expert. But the point being, I tagged David Yannetti, as I'm sure many, many people did. I'm like, this is exactly what you need tested by an actual expert, and do it quick because trial's in 3 weeks and it's a late disclosure as it is. You're going to have a problem getting it in. However, I think it's that important. I think it's that telling because the pushback I saw on Twitter today is people kept posting the picture. Oh, you can clearly see in this video from the driveway that was taken at 8:30 that the taillight's clearly gone. I'm like, I can't tell anything from that. What I can tell is that if in fact it looked the way the Commonwealth is claiming that it did when it drove into the sally port, that there is no illumination coming from the bulk of the tail light. That's what I know. And he shows it all. And then he goes through, it's an 8-minute video. It's 8 minutes of bliss. It really gave me the best sense of how that thing operates out of anything that I've ever seen, which when you think about it is a crying shame because why nobody on either side thought to do that at the first trial is kind of beyond me. Or like why ARCCA didn't do that. I mean, come on.
I don't think ARCA needed to do that for the purposes of what they were testing, and since they weren't hired by the defense didn't have the ability to expand their investigation
Yeah, but
and their
they're
testing.
really smart. And if they're like, okay, in our testing, when we used the identical tail light and we did the testing, one thing of note that we noticed is that when you take the thick red plastic away from the tail light housing, the thing does not illuminate anymore. This is not like the old days. So every modern vehicle does not use bulbs anymore. They use LED lighting. So everything is LED these days. So if people are under the impression there's a bulb in there, that ain't it. It's like I thought everybody knew that. Like everything is LED these days. There's bulbs are very hard to get. And when you do buy bulbs, guess what? They're LED. It's like you got to really, really dig. You really wait. Are you saying there is? There's a bulb in there. Did you see a bulb? I didn't see a
I
bulb.
thought he showed at the I thought that's what was at the top, the little red it was a red light
I
at
thought
the
it
end.
was LED. Yeah,
I'm
but
not
that's what
sure,
I'm
but
saying.
whatever
This
the case may be. But this brings to the question that many of you have, which is, is it too late for the defense to get this evidence in? And I don't think that it is. It's something they can explain that has just come up. It is not something that requires any sort of special expertise. It sort of is what it is. They could do it almost as demonstrative. You don't need an actual expert. Um, Necessarily. You just need someone to come in and say that they did this testing on it, and it's not like expertise in the sense that you need a Daubert or you need to establish what their training and experience it is to do such testing. It's something that any layman can see with their own eyes. They just have to be presented with it. So, although as Bob said, it might be considered late, I don't think it's something that she would rule out. I think there is still plenty of time to deal with that type of evidence.
Okay. So I'm trying to figure out the best way to do this with the volume. So what I'm going to do instead of us reading through all of them first, I'm going to throw them up and I'm going to pop them up real quick. And we're just going to read the headings. And then when we get to the affidavits, people will at least have a frame of reference to what that affidavit, which motion it is pertaining to. Does that make sense?
It does, however, the affidavits are very specific and they're entitled the same as the motion. So I think it's fine to um, do it that way or to start with
Some
uh,
of the affidavits are pretty bare bone though. I mean, I'm
right.
just gonna
It only works for some of the motions. There are a lot of them, and I think that for some of them, for example, there is a motion which so for those of you that don't know, Aiden Carney interviewed a one of the jurors on his YouTube channel, um, also known as Turtle Boy. During that interview, the juror made crystal clear, which was one of it was by far what troubled me the most and what was most shocking from what or one I'm sorry, of the most shocking things that came from my perspective was that the jurors completely discredited ARCA because they became even more suspicious because they were not being told the background, where these witnesses came from, how they came to test things. So I think that the motion, for example, on that, the affidavit sort of lays out the entire defense's theory and position as to what they're asking the court to do in light of that this time around. And I am so glad that this motion was brought. I was screaming from the rooftops with Bob, like, oh my goodness, could you imagine? Like, they need to go back and get something else for the new trial because their primary experts were completely discredited by the jury because of Judge Canoni's rulings.
Yeah, indeed. All right, so let's start with this one. Affidavit of counsel in support of defendant's motion in limine to allow counsel to state grounds for objections. Thank God. Thank God. Was there anything more that bugged you about that first trial than when she would not allow them to state the basis of their objection? Do you
I
remember
it
that?
I do, of course, but then we learned that that is standard operating procedure in Massachusetts, which was almost why I thought for this one, we might also wanna look at the law, but
Yeah,
let's
guess
start
what? It's a stupid, stupid rule. It defeats the
yes.
entire purpose of objections because of the appellate court more than anything else. The appellate court, and you so aptly explained it way back when we were covering that trial, that the problem is that leaves the appellate court way too much leeway in terms of looking at the potential issues and say, okay, well, we're not sure what the basis of the objection is. So in that case, we are going to apply all the potential different bases for this objection, and then we're going to pick them off one by one.
And say the
So
judge made the right decision, assuming that was the objection. Now, that does work for both sides. It allows the defense to just say objection, and then appellate counsel to raise every single possible valid objection that they want to raise as the bases, presumably. So I think for that one, babe, maybe we should pull up the motion, just read the the uh the local rule that's at issue, and then switch over to the affidavit.
Okay, so it's state grounds for objections. All right. I'm gonna have to whip through them all. This is gonna be a thing. There's a lot, babe.
There's a lot.
Okay. That's
It's got a
Commonwealth.
number at the top,
That's Commonwealth. Oh, okay.
so that's gonna be helpful to you because that's what she during trial or hearings, you'll notice the judge always asks, "What document number is it?" And they have a handwritten number, on top of each of these documents.
wow.
I was
Okay.
trying in the meantime to go look back um, at the at the comment on B in Trouble 31's video to see if he possibly responded to your request to use it, but I can't find, um oh, there it is. No response.
Wait, where?
I
Oh,
found it on his YouTube. I just had to switch to newest instead of top. But I think you're right. This is someone who's got a lot of other things going on in their life than sitting around watching their YouTube blow up.
I mean, unless it's really blowing up, then it's fine. Because then that's super fun.
I mean, it's definitely blowing up to the sense there was 100 and
Ah, I found it, babe.
very good, 120 subscribers this morning, and there's 313 now. So, I mean, relative to where he was.
Okay, so here's the actual motion. Defendant's motion eliminate to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve the issues. I saw Julie Frew that said that Andrea likes that. I'm gonna have to disagree with our esteemed colleague there. I don't like
She
anything about it.
she likes that they don't have to state it, and I think I'm telling you that's why from an appellate position, um, it's great to just be able to say objection and then be able to come up how many times a lawyer puts the wrong objection or doesn't state the grounds, and then the appellate court is saying, "Well, you didn't at least in Illinois, you didn't state the grounds. This you might as well have said, you know,
Yeah,
blah,
but the
blah, blah,
counter
blah."
argument to that is it's hard enough to win an appeal, and when you give the appellate courts all the discretion in the world to apply whatever single basis for an objection that they can think of in order to deny that appeal, I think that's the counter. That's the counter argument
But
to it.
again, it works in the reverse and says they can consider every possible valid ground.
I
But
get it.
the biggest thing for me, the biggest problem for me is it doesn't give the responding attorney the opportunity to adjust and address the objection made. For example, if it's hearsay, you can state your exceptions. Well, I'm going under this exception. So if they state the ground, then you can change the format of your question. You can do something different that you can't do with it if you're just guessing what the grounds for their objection is. Um, but
All right.
see if they cite the rule in here.
Okay, so I'll cut down here. It says okay, so I want to read footnote 1. So footnote 1 says underside counsel would like to note that this is not a request for lengthy speaking objections. Any issues that could be perceived as having an ability to coach a witness while on the stand or potentially bias the jurors with extraneous information will still be dealt with at sidebar. Counsel is merely requesting the ability to state grounds for their objections. By way of example, rather than simply stating objection, counsel would state objection, hearsay or objection calls for speculation. So, as the grounds for this motion, Ms. Reed states that the court's general order that counsel not state grounds for the respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive jury trial. Ms. Reed further states that the inability of defense counsel to state grounds for objections could lead to their inability to preserve issues for any necessary appeal. Stating the basis for an objection in a word or two will not cause either side any prejudice. While Ms. Reed acknowledges that generally considerations of judicial economy must yield to the defendant's right to a fair trial, followed by footnote 2. Oh, hold on. I got to get into scrolling. Citation. In this instance, it is the defendant making this request. Massachusetts courts and the rules of criminal procedure have outlined several scenarios that demonstrate the general promotion of an interest in judicial economy and efficiency. So let's see. Additionally, the Supreme Judicial Court has condoned the practice of taking motions for mistrial made during closing argument under advisement until after the return of a jury verdict to promote judicial economy and the efficiency to preserve, quote, valuable judicial resources by obviating the need for a retrial should the jury return a verdict of acquittal. I like how they snuck that in there. Finally, judicial economy was explicitly cited as a consideration by the Supreme Judicial Court in eliminating the so-called, quote, power of resurrection in criminal cases. There are many rationales, and this is a quote from the case. There are many rationales for the raise or waive rule. That is a necessary corollary of our adversary system, in which issues are framed by the litigants and presented to a court. Oh, I mispronounced corollary. So that fairness to all parties requires the litigant to advance his contentions at a time when there is an opportunity to respond to them factually, if his opponent chooses to. That the rule promotes efficient trial proceedings, that reversing for error not preserved permits the losing side to second guess its tactical decisions after they do not produce the desired result. And that there is something unseemly about telling a lower court it was wrong when it never was presented with the opportunity to be right. The principal rationale, however, is judicial economy. There are two components to judicial economy. One, if the losing side can obtain an appellate reversal because of error not objected to, the parties and public are put to the expense of a retrial that could have been avoided had an objection been made. And two, if an issue has been raised in the trial court, it could have been resolved there, and the parties and public would be spared the expense of an appeal. Okay, so he then gets into the power of resurrection doctrine, which I'm gonna
Wait,
skip. Do you want to look at it?
yeah, just so they note that at least one occasion, it led to an appellate court holding that counsel had failed to preserve an issue. They note that that is an unpublished opinion, but I'll note again, that's what happens in Illinois. If you don't follow your objection with the grounds, cause for speculation, hearsay, as he used those examples, you might as well have said boogity boogity boo. You didn't object. It doesn't count. And they're saying that that at least happened in one occasion in the Commonwealth.
So why don't you read the key passage from Cabral Varela? Because it's probably interesting.
The most hotly contested issue at trial was the identity of the shooter. The Commonwealth sought to establish the defendant's identity in part by introducing a security video of the shooting that showed the shooter wearing a white T-shirt and eliciting evidence that was what the defendant habitually wore. This evidence consisted of testimony that to the effect from a percipient witness, a police officer who was familiar with the defendant, and a police detective who had participated in the investigation and had viewed the defendant's social media pages. Dugan, who was the police detective, also authenticated 2 social media photographs of the defendant wearing white T-shirts. The defendant argues on appeal this was inadmissible habit evidence. The parties disputed the standard of review with respect to habit evidence. The defendant argues the issue was preserved and that the standard of review is for prejudicial error. The Commonwealth argues it was not, and the standard of review is for a substantial risk of a miscarriage of justice. Now, I'll just note here, that is the difference when you make an objection or you don't. If you don't make an objection, if your lawyer somehow messed up or something was not properly preserved, the issue becomes, is there a substantial risk of miscarriage of justice, at least here, as the Commonwealth is noting. So the court goes on to say, we agree with the Commonwealth. The prosecutor twice asked Swan whether a defendant typically wore any particular type of clothing. Defense counsel objected to the first question without stating his grounds, and the judge stated sustained as to foundation. So that there's important. The prosecutor immediately laid a foundation and asked the question a second time. Defense counsel again objected without stating grounds, and the judge overruled the objection. In these circumstances, it is clear that the overruled objection was based on foundation grounds, which is insufficient to preserve an objection on habit. And they cite a case for that. While defense counsel objected at sidebar shortly before Dugan's testimony, the objection was only to the introduction of the photographs, not Dugan's testimony, and was on cumulativeness grounds, which is also insufficient to preserve the issue for appeal. There was no objection at all to Moody's testimony. Now, I'm just going to say here before we go on with what the court had said. So I think part of the defense's issue is, okay, yeah, we can step up for sidebar like every 2 seconds, or, before they start. It sounds like in this case, it was like before the person even testified, they had a sort of a sidebar saying what his issues were, what he was going to object based on. But it's different when you're standing there and it's happening and something comes to mind. And, I don't know if they're saying literally every single time someone says the word objection, they're going to walk forward and say what the basis is. But in any event, the court basically went on to say that the defense counsel's failure to state the grounds for his objection led the court to infer the grounds, and having done so, to determine the defendant was entitled to a less deferential standard of review, which he otherwise would have been entitled to had the correct issue been preserved. Although the court went on to say that the court had applied a more deferential prejudicial error standard, which it did not, the court would still have determined that the error did not influence the jury or had a very slight effect. So they're basically just going on with the fact that in that case, the Court of Appeals had agreed with the Commonwealth that since the defense had failed to properly preserve the issue, they had to use a different standard of review. So now you can switch over to the affidavit, although we might have covered everything through what we said here, but
Yeah, and I don't. So obviously they didn't cite any kind of local rule there. That's actually a rule. So I mean,
but I have heard Judge Cannone say it in the courtroom, that's the way we do it in Massachusetts.
Okay. So this is the accompanying affidavit of counsel of David Yannetti. So during the first trial in this matter, the court's general order that counsel not state grounds for their respective objections before the jury led to extensive discussion at the sidebar, which lengthened an already extensive trial. Okay, cognizant of how counsel was appearing to the jury, which was forced to endure multiple and often lengthy sidebar conferences, and us with OnlyFan, like we spend a lot of time with OnlyFan because of that. There were times when it was unclear that the basis for a Commonwealth objection and the court's ruling was, or what the basis for the Commonwealth's objection and the court's ruling was. Yet, so as to not further aggravate and or annoy the jury, the defense was forced to, quote, pick its battles in calling for a sidebar discussion of an evidentiary issue. In this way, our duty to zealously represent our client faced conflicting concerns, preserving the record versus maximizing our credibility before the trial jury.
Great points. Great points.
4, based on our legal research, there is at least one instance where defense counsel's failure to state grounds for his objection, 1, led the appeals court to infer what the grounds for his objection were, and 2, having done so, to determine that the defendant was entitled to a less deferential standard of review than he would have been entitled had the correct issue been preserved.
And that's the case that we just discussed when we read the motion itself.
Exactly. All right. So 5, I believe the same issue could recur in this matter, absent a modified order from this court regarding counsel being able to state the basis for objections briefly and succinctly. And that's how they do it in our courts. I mean, it's a judge by judge thing here in Illinois.
No, I've
Some judge
never, ever, 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 ever,
No,
ever.
I'm not talking about not stating the basis. I'm talking about we have judges that will allow for speaking objections, but we have judges that are adamant, like no speaking objection, like Barsanti, like when he
Well, but
nailed.
again, and let's just explain the difference between a speaking objection and stating your grounds. It's one thing to say, Your Honor, objection, hearsay. It's another thing to say, Your Honor, objection, hearsay. This was said by Joe Blow when he was sitting on the corner of the street, like where you're explaining why it's hearsay. And in that case, some judges will let you get away with throwing a little bit more in there, but for the most part, any sort of speaking objection, you have to say, Your Honor, you'd say hearsay, they'd respond, you say, Your Honor, can we have a sidebar? And then you'd explain why you still believe it's hearsay or what the facts that underlie your argument are. So, and he made it clear in the footnote that Bob read when we were reading the motion itself that he's not asking to give any sort of speaking objection, just state the grounds, no other words.
So 6, otherwise, if the court maintained its prior ruling on the form of objections during this retrial, we believe that this could infringe upon Ms. Reed's right to a fair trial and any appellate rights she may need to exercise, should she need to exercise them. 7, I believe that allowing counsel to state objections would promote judicial economy and the fair adjudication of this trial, as well as avoid any potential appellate issues that counsel were not able to state grounds for objections without approaching sidebar. 8, I believe there will be little to no prejudice to either party in stating a legal basis for the objection in a word or two in open court. Accordingly, do it, judge, do it.
So, and I'll just say, if the judge were not to allow it, I think the only other thing that she could do and she should do is after every single objection, she calls them forward. So that way the defense doesn't have to ask to come forward. It doesn't have to seem like it's the defense doing this. They don't know. That's just the standard courtroom protocol. Somebody objects and I call them forward, period. Which obviously it's not good for judicial economy, but it resolves the the issue the defense has with not being the one to always have to ask to come forward, and then the jury be like, what is their problem? What is going on? Why do they have to go up and ask the judge something every 2 seconds?
Okay, so taking your approach, the second affidavit we're going to check out is the affidavit of counsel in support of defendant's motion in limine to allow evidence of lack of bias.
And this goes to the ARCCA witnesses. So you want me to read this?
Sure.
So this is Yannetti again, and he states, 2 witnesses from ARCCA testified during the defense case during the first trial in this matter. Dr. Daniel Wolf, PhD, and Andrew Rentschler, PhD. The defense did not initially retain or involve those experts in this investigation. They were instead retained by the U.S. Attorney's Office for the District of Massachusetts as part of their probe into the investigation of the death of Officer John O'Keefe. Each of these expert witnesses performed their testing and analysis pursuant to the mandates and at the request of the United States Attorney's Office. The defense had no input into what manner of testing or analysis they would be performing, nor what materials they were allowed to consider. Prior to the first trial in this matter, as discussed at length during hearings on February 18th, February 25th, and March 5th of 2025, the defense did not pay ARCCA prior to their testimony. At the first trial of this matter, the defense was prohibited from mentioning the federal investigation into this matter at all. Consequently, the jury was not allowed to consider that the ARCCA experts were not retained by the defense, were not instructed by the defense to perform testing, were not provided by the defense any materials to consider, and were not involved with the defense at all prior to completion of their testing. The inability of the defense to explain the origins of ARCCA's involvement in this case led to juror confusion and prejudiced Miss Reed. Amen.
Amen.
After the trial, Jurors have come forward to express their confusion about ARCA's testimony. At least one surmised that ARCA must have been retained by Miss Reed's car insurance company, in parentheticals, which would lead to an inference of bias in favor of Miss Reed's version of events. At least another postulated that ARCA experts were fame seekers. Having heard about this high profile case, they wanted to insert themselves into the trial to gain positive publicity for themselves and ARCA. It is ironic and wrong in
Which was
retrospect.
the same argument, I'm sorry, that they were making about Dr. Russell. I mean, like, the thrust of the beginning of that examination, the cross-examination by Lally of Dr. Russell was, "Oh, well, you read about this in the paper, and you wanted to inject yourself into the case," and you know what I mean? It was like that whole thing.
And the jurors took that to heart, and they
Yeah.
did discredit some of her, or they gave less credit or credence to her opinions based thereupon.
Well,
I'm
and
surprised.
she preceded both Wolf and Rensler, and that concept that Lally put forth as to her stuck to them, and they were the last 2 witnesses.
Right. So moving on, paragraph 8 says, "It is ironic and wrong in retrospect, in my view, that this court was seeking to have the jury avoid speculating about a federal investigation, but in doing so, caused the jury to speculate about ARCA in a way that tended to diminish their credibility and therefore diminish their effectiveness for Miss Reed." That is huge.
Huge.
That's what happened. It's outrageous. We need to understand that in every court of law, in a criminal case, there is typically a state police agency, a federal agency putting forth evidence, testing DNA evidence, testing this, testing that. Do you think on those bases that they don't allow them to talk about their background, what they do? Yeah, we're FBI agents. It is the same thing. If they're supposed to, if the fact that they were retained by the FBI should make them more credible, or specifically and importantly, less biased towards either side, unbiased at the time of their giving their opinion, then that is a benefit that the defendant is entitled to. That is a benefit that the witness is entitled to. That is something the jury has damn well the right to know. And she has got to take this back when she sees how this came about. Now, the question becomes, how are they proving this? Is there an affidavit from a juror, which is what should be here, to be perfectly honest? Um, so that might be problematic. They do have the one juror saying it, and I would have put a link to that portion of the YouTube, cited it directly. Um, Maybe it's in the body of the actual motion itself, but this is something she needs to figure out a way around. They have to know that where these witnesses came from, who employed them, and why the defense didn't have the ability to uh, have to sort of guide the investigation and what they're testifying about and the materials that they reviewed. And the fact that they drew a negative inference is
Well, that's the
unacceptable.
thing. That's the thing. Moreover, you don't want a jury sitting there during the course of a trial wondering and trying to figure out who these witnesses are and why they're there and whether or not they're a hired gun. I mean, like, that can't be hidden from the jurors. They wasted so much time thinking about who these people were. Do they work for an insurance company? Was this as a result of the accident? They came to improper conclusions and they speculated about things that they didn't need to had they simply been told where these 2 people came from. Because I'll tell you for damn certain, if the reports had come down on the Commonwealth side, they would have absolutely been arguing, "Hey, of course we should be able to tell them that it's the feds and it was an independent vet." What's again, I say it constantly, what's good for the goose is good for the gander. And if Brennan were to sit there and say for 1 second, "Oh, well, if the report had been for us, then I wouldn't have wanted I would have had the same ruling. I would have wanted that to apply to us. They don't need to know. Yeah, they do need to know. They need to know for the exact reasons that Ronnie, in every interview that I've seen him in, and speaking about the ARCA, the two ARCA witnesses, has stated we didn't know who they were and why they were there. And because of that, they made improper inferences as to who they were and why they were there. So that's a really easy remedy. It doesn't hurt either side. It's a too bad so sad situation.
Right.
The
I mean, it's
testing
the
was done
truth.
prior to it was not at the behest of anybody involved at this trial, and they came down the way they came down.
And
And
she
both
doesn't
sides had
have to
the opportunity.
sorry.
Both sides had the opportunity to go ahead and use the report. And it just so happened it happened to work in favor of the defense.
Now, Judge Cannoni's concerns, partially valid, are she doesn't want the jury speculating about the reason for the FBI investigation, because uh, that could go poorly as well. You don't want them thinking they were investigating Karen Reed. She doesn't want them saying that they were investigating the cops, which you know,
I think that because that possibility exists, there's no bias to either side. I'd rather have them speculating as to one of those two things than wondering who the hell they were and why the hell they were there
right. And so
at all.
the defense doesn't need to be able to say the FBI hired them to investigate whether the police officers were covering up for another police officer, whether they did anything improper to shield other police officers from speculation. Whatever the case is, they don't need all those details. They just need to be told that the U.S. Attorney's Office hired them to do an independent investigation. And they did. Now, might that also, because Bob, that does raise the question. I'm a juror, right? And I hear, well, I guess not when I hear their testimony. I was going to say, and I hear that the FBI hired someone to do an independent investigation, but then charges still got brought. I might be left thinking, well, the FBI must have agreed it was Karen Reed. But then I'm walking back my own logic, because clearly once they hear the testimony is that car did not hit that man, then they're not going to be left thinking that the FBI agreed um, that Karen Reed should be charged. Or I'm sorry, that the U.S. Attorney's Office agreed that that Karen Reed should be charged. So
Well,
I think
Judge
the judge needs.
Cannoni's
No, I was just going to say I think she needs to do something.
Yeah, I mean, Judge Cannoni's ruling ended up taking the incredible power that these two witnesses possessed by truly being independent by making that ruling. She stripped those witnesses of it. It's the thing that I kept screaming and yelling about that made these two witnesses so impactful, was the fact that they were not hired guns, that they weren't state employees, and that they weren't hired by the defense specifically to come up with a report that they would find usable at trial. That's what made them so very powerful. And she stripped that from them, which I think strips Karen Reed in her
Of a
entire
fair
right to
trial.
a fair trial. That's
Absolutely. It
unequivocally.
hands down, it is black and it is white. It should have never happened in the first place. I just don't think anybody anticipated it going so poorly. I'm sure the defense assumed that by kind of laying all of this out, that at the end of the day, the jury would still get the sense that this was an independent, unbiased investigation that landed where it landed, and that is not the case. And um, you know, she's going to have to rectify this, and I don't know the answer to whether or not it's something that they could appeal interlocutorily, but I would venture to guess no. Not in most states that I am aware of, this is not something that could get appealed. It has to wait till after trial.
Yeah, and just for the record, if I hear one more prosecutor in this country talk about how the state has the right to a fair trial, my head's going to explode. That the Sixth Amendment applies to defendants and defendants only. Period. End of conversation. All right, continue reading this thing. I think you were at 9.
Okay. Probing the bias or lack of bias of a witness, including an expert witness, is a constitutional right possessed by every criminal defendant. Robbing the jury of the truth of the origin of ARCCA's involvement in this case robbed the jury of the appropriate opportunity to give appropriate weight to the opinions of the ARCCA experts.
Yes, yes.
The testimony of these witnesses, based on their analysis and findings, corroborates the essence of Miss Reed's defense. Officer O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to Miss Reed's SUV consistent with colliding with a pedestrian. Allowing these witnesses to explain that they were initially retained by the DOJ and not by the defense, an insurance company, or a rogue third party provides important context for their testimony. The Commonwealth is, of course, free to explore their allegations of bias during cross-examination.
Here, here.
And when they speak of that, their allegations of bias, they're talking about the recent allegations of the Commonwealth that they had were able to have conversations with them, had some influence over their testimony, where at the end of the day, the defense's position is, but regardless of all of that, their testimony is consistent with their initial opinion. Nothing changed.
Nothing changed.
And that's important. So moving on, in paragraph 14, defense, Mr. Yannetti states or affirms, not stating who retained ARCCA experts to conduct their testing, however, keeps important context from the jurors and causes confusion. The defense is not seeking to mention the existence of a federal investigation when questioning these witnesses or during any other part of the upcoming retrial. Accordingly, I believe it's in the interest of justice that this honorable court allow this motion in limine.
All right. So I think that particular affidavit was thorough enough that we, in fact, do not need to read the actual motion. All right. I think we went through this one. This was the defendant's motion to allow objections on the basis be stated. So this is defendant's motion to impound the defendant's motion eliminate to prohibit the Norfolk district attorney and Massachusetts state police from having juror contact. So this one's pretty short and sweet. Now comes Karen Reed through her attorneys and moves the honorable court asking for an order impounding the defendant's motion to prohibit the Norfolk district attorney and the Massachusetts state police from having juror contact because the exhibits supporting the motion as well as the discussion of those motions are subject to this court's order of impoundment. Specifically, the transcript of June 25 sidebar conference exhibit A and the text message exchange, which included Lieutenant Fanning and Trooper Proctor exhibit B, must both be filed under an order of impoundment.
And there is a corresponding affidavit. I'll just tell you real quick because it's one sentence, and it just says, good cause exists to file this motion under order of impoundment because the court ordered that both exhibits in support of the motion are subject to orders of impoundment. So basically, this is just the defense saying, allow me to file this, as we usually call it, under seal. And it appears that it was, in fact, filed under seal.
Okay, so see, now that I see the motion, I kind of take it back. It's lengthy. I mean, do you want to get into that bias thing, or do you feel like we covered it thoroughly enough, babe?
Well, I'd say now that you've tempted people with it, you might as well read it because I don't want to be on the wrong side of our audience. I'll tell you that.
Yeah. Yeah. Are you saying my Boston accent is Chicago? Probably. I mean, I am from Chicago. So I'll skip so it's obviously relating to Wolf and Runchler again. As grounds, therefore, Ms. Reed states that their retention by the U.S. Attorney's Office and not by defense bears directly on their credibility. Rebuts any contention by the Commonwealth of bias and will avoid causing the jury to unfairly speculate about the origins of their involvement or otherwise prejudice Ms. Reed's constitutional right to due process in a fair trial. So footnote 1 up here said Ms. Reed wishes to clarify herein, in light of information sought by the court during recent motion hearings and disclosed by the defense as reciprocal discovery, the defense was invoiced by and did pay ARCA only following the conclusion of the first trial. The defense intends to comply with its reciprocal discovery obligations pursuant to the rule, including in continuing its continuing duty to disclose should it acquire any additional discoverable information following the March 6th reciprocal discovery deadline. So the factual background. So on day 31 of Ms. Reed's first trial, both Wolf and Rensler testified. Wolf and Rensler stated they were neither hired by the defense nor the Commonwealth. In fact, these two employees of ARCA explicitly articulated that they did not have contact with the defense or the Commonwealth regarding the specifics of their testing, did not consult with the defense or the Commonwealth. And Dr. Wolf himself clearly noted that ARCA employees were, quote, hired by another agency, not connected in any way to the defense. The particular agency was left for the jury to speculate about, and at least one member did. See affidavit, page 2. The independence of these ARCA employees, specifically Wolf and Rensler, was reaffirmed during motion hearings ahead of Ms. Reed's second trial. And then he cites to the transcript of the trial. Nevertheless, these individuals who will serve as two of Mrs. Reed's most critical exculpatory witnesses were indisputably engaged and hired by the United States Attorney's Office to conduct their independent review, analysis, and testing surrounding the singular question of whether Mr. John O'Keefe died as a result of an auto pedestrian collision with Miss Reed's SUV. These highly qualified experts have determined to a reasonable degree of scientific certainty that one, Mr. O'Keefe's injuries and death did not result from being struck by Miss Reed's SUV, and two, that the damage to Miss Reed's SUV did not result from colliding with Mr. O'Keefe. In other words, the scientific data establishes that Miss Reed did not strike Mr. O'Keefe with her vehicle. Both Dr. Wolf and Rensler, two individuals who were not hired by the defense to perform their testing, testified to this highly relevant and exculpatory fact during Miss Reed's first trial and during voir dire, under oath and under threat of perjury. Furthermore, the Commonwealth, by its own admission, had admitted that, quote, it's not the ARCA witnesses that I have issues with. Motion hearing transcript. Moreover, the Commonwealth stated that it, quote, doesn't care if the ARCA witnesses testify at trial. I don't care about their opinions. I'd welcome ARCA. He's so full of shit. And I'm talking about Brennan. Most recently, the Commonwealth communicated to this honorable court on February 25th, 2025, that, quote, there is a murky relationship between the defense and the U.S. Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of the interaction between the defense and the ARCA witnesses. Again, cites the motion hearing transcript. The Commonwealth has additionally conceded that, quote, we still don't know the relationship between the defense and ARCA. We don't know about the impact it has on the first trial, or had, it should be. Again, id at 126, that's transcript. The Commonwealth has provided no objection or legitimate legal basis for not disclosing in Ms. Reed's second trial that employees of ARCA were hired by the U.S. Attorney's Office. In fact, the Commonwealth itself has articulated there is a lack of clarity about key information pertaining to these potential witnesses. If the Commonwealth, who has been privy to the relevant discovery for months and has had an opportunity to question these witnesses during voir dire in Miss Reed's first trial, has expressed confusion about the nature of the relationship between ARCA and the defense, then it is only logical that the jury, too, might be confused by the nature of ARCA's involvement without a full and complete understanding of how, why, and by whom these individuals were hired.
Touche.
Touche. Or as I like to say sometimes, douche.
Wow, that's
Hank
so
Brennan.
douchey.
Yeah, well, Hank Burn's a bit of a douche. So argument one, to avoid unfairly prejudicial speculation, this court should admit the fact that the U.S. Attorney's Office hired and retained employees of ARCCA. Proof of bias or lack thereof directly bears on the credibility of a witness. It is never collateral in nature, and extrinsic evidence to prove it is permitted. In criminal cases, then cites State v. Williams, Davis v. Alaska, U.S. v. Anderson. In criminal cases, the defendant's right to confrontation provides a constitutional basis for admissibility. Then cites Olden v. Kentucky, Delaware v. Van Ardstall, and Gardner v. U.S. Indeed, a criminal defendant has a constitutional right to show bias. Commonwealth v. Kindle. If the defendant demonstrates, and this is a quote from a case, y'all, if the defendant demonstrates that there, quote, is a possibility of bias, even a remote one, the judge has no discretion to bar all inquiry into the subject. Quoting Commonwealth v. Tambui. Bias is the relationship between a party and a witness, which might lead the witness to slant, unconsciously or otherwise, his testimony in favor of or against the party. Bias may be induced by a witness, like dislike or fear of a party, or by the witness's self-interest. Proof of bias is almost always relevant because the jury, as the finder of fact and weigher of credibility, has historically been entitled to assess all evidence which might bear on the accuracy and truth of a witness's testimony. U.S. v. Abel.
Now, that is very compelling legal precedent that they're putting forward here. That is constitutional law that goes directly to the right to confrontation, the right to present a defense. And sorry, if I think she's got to rectify this, but if she doesn't, and Brennan even tries to hint about any sort of bias, he asks any question, were you paid? That's a question that goes to bias. Then that opens the door to getting in the truth. And I think it's fair to say that the U.S. Supreme Court, the established law on this says this is allowed in. And like Bob said, oh, too bad, too sad if it actually helps the defendant. You know, gives their witnesses an extra edge because it's a deserving extra edge. It's what they are entitled
You know what
to.
it is?
The truth?
It is what it is, sucker. It is what it is. That's it. The report is what it is. So during the first trial of this matter, the defense was prohibited from mentioning the federal investigation into the investigation of this case, affidavit part 2. That prohibition extended, however, to the fact that the Department of Justice retained ARCCA completely controlled the material that they were to review and the testing they were to perform, affidavit page 2. So to the extent that the Commonwealth impeached these witnesses by pointing out the material they did not review prior to performing their testing and forming their conclusions, the Commonwealth left the impression that the defense improperly withheld certain materials from those witnesses. This is such a critical argument.
Yes, or that somebody
Exactly what
did. Even if it's not the defense, it's that somebody did, and they interpreted that as someone defense cited.
Right. I mean, who else could it be other than defense? Because a jury doesn't know if the defense is
Well,
calling them. They're assuming that it's a defense witness
but
that
they
was
did
hired
make
in some form or fashion.
but they did make abundantly clear that we didn't hire you. You don't know us. We never talked to you. Da, da, da,
Who
da,
pulled the doc down? Did you?
da. I
Pulled the
did
doc
not.
down? Huh.
I did nothing of the sort.
Mandy. Oh.
Oh,
Okay. So to the extent that the Commonwealth impeached these witnesses by pointing out the material that they did not review prior to performing their testing and forming their conclusions, the Commonwealth left the impression the defense improperly withheld certain materials from those witnesses. That was a false impression, and prejudice misreads defense by keeping relevant rehabilitation and credibility evidence from the jury. Hear, hear. Hear, hear. That is so true.
I cannot like scream loud enough or repeat more how important this motion is and how important it is that Judge Cannoni make the right ruling. And I would hope when presented with this argument, now I have to admit that I didn't we didn't follow the pretrial motions the first time around as closely, so I'm not sure how much of this same argument that they made in the first trial. I suspect it was not as strong. I don't think that they anticipated, as we said before, that the jury would so badly misinterpret the relationship and speculate in a way that was so detrimental to the defense. But if you are allowed to go on about what they didn't review, and if you knew this, would that have changed, and how come you didn't get this, and the defense has to have the ability to say that this was the Department of Justice's decision on how to get the most independent assessment. Just give them X, Y, and Z and tell us what happened.
Yeah. And as far as they were so concerned about just being able to get those witnesses in with the whole voir dire of them and everything else, they didn't argue this in terms of her ruling that she wasn't going to allow them to articulate exactly whom they were hired by. So like that didn't get we were covering everything at that point. This all happened on the eve of trial. So by that time we were all in on it. So they didn't argue this, certainly not in this form or fashion. There's no question about that. So worse, the inability of the defense to reveal. I would argue that this is the most critical motion out of everything that was filed
I would too.
today by a million miles. That's how important these two witnesses are to the defense's case in chief and to Karen Reed.
Yes.
So
And to a fair trial.
worse, the inability of the defense to reveal and or explain ARCCA's initial involvement in this matter led to jury confusion that also prejudiced Ms. Reed. Post-trial, jurors contacted the parties and or made statements in public about the jury's view of ARCCA's involvement. I can't see what page number, at least one member of the jury surmised that ARCCA must have been retained by Miss Reed's insurance company. That assumption would lead to an inference of bias in favor of Miss Reed when none existed.
In favor of? They should have said against.
No,
Oh, bias in
if it's
favor of.
her
Yes.
insurance
Okay.
company, right?
Right.
So that
Bias in
assumption
favor
would
of.
lead to an inference of bias in favor of Miss Reed when none existed. At least one other member of the jury speculated that ARCCA witnesses were seeking to insert themselves into the case for fame or other publicity.
Can you
That
scroll up
assumption,
and see what it is
it is the affidavit.
of Giannetti?
No, I think I don't know where he cites it. I thought it might be some reason I thought maybe it was actually Ronnie. I don't know.
Well,
Maybe
that would be what we'd
that
want
would be
to see.
huge. Hold
Here,
on.
I'll look while you keep reading, and I'll figure it out, and I'll
See if you
chime
can
in
find it.
and
See if you can
let you
find
guys
it.
know.
I think I was just reading that in the chat. It probably wasn't Ronnie. If it was Ronnie, that would be a game changer, y'all. But I don't think it was Ronnie. Okay. I can't remember. Okay. So that assumption would lead to an inference that their testimony should be unfairly discounted. Importantly, identifying explicitly that neither defense nor an affiliated third party initially hired these ARCCA employees is not only crucial to Miss Reed's case, but it is also relevant evidence that is inherently admissible. See Rule 402 of the Mass Rules of Evidence. It is also entirely true, as is the fact that the conclusions of the ARCCA witnesses were made before either party was even aware of the existence of the witnesses in any matter pertaining to Miss Reed. Additionally, there are no permissible grounds under the Massachusetts Rules of Evidence to exclude such relevant and exculpatory evidence, particularly in response to any hypothetical and or unsubstantiated concerns that, quote, unfair prejudice or, quote, misleading the jury would occur by presenting such information. See Rule Mass 403. In fact, presenting to the jury that the employees of ARCCA were initially hired by the U.S. Attorney's Office would serve to prevent juror confusion. Indeed, excluding such relevant and exculpatory evidence would mislead the jury, which it did.
So I'm just gonna say it just says affidavit, so it's got to be, Yannetti's affidavit
Yeah.
because
Wait.
I don't see
Oh,
any other it just literally the first time that it's referenced, it says, "See affidavit."
what did they say that they
See
were
so I'm
impounding?
sorry, "See affidavit of counsel in support of this motion here and after, quote,
Which,
affidavit." So
which,
anytime
so that's got to be it, right? Yeah.
right, there's no other affidavit here.
Okay. Okay. So the trier, in fact, in this case, the jury is entitled to hear relevant evidence, particularly which, quote, makes a fact more or less probable than it would be without the evidence. And where, quote, such fact is of consequence in determining the action. Rule 401. Knowing that employees of ARCA were not hired by the defense or Commonwealth and instead were hired at the time they performed their testing by a neutral third party can and should add legitimacy to the credibility of these individuals' testimony. And it does. It's so big. It's so big. It's what I kept. It was so big to me that I thought that they should shutter all of the conspiracy stuff, just put it aside, and just put these two guys on the stand. Case closed. That's how goddamn big I thought it was, and
Yep,
still do.
and the fact that jurors discounted it because they didn't know where these witnesses came from, how
It's
they got involved.
outrageous. It's outrageous. And when the fix is this simple, she has to figure out a way to do it.
And I do think that Judge Canoni has proven she does read all of the motions. She makes sure she's got her copies of them. She's got the way that she's got them lined out. She keeps her exhibits. So she is definitely reviewing everything. And
Yeah, and
I
she definitely focuses on when she thinks the defense is being shady. She memorizes, she commits it to memory. She
yes,
doesn't even no, she does. She said it. Oh, I remember. I don't have to look at the transcript. I remember that conversation verbatim. Like, I mean,
yes.
that's out there.
But I do think and I know with Judge Gull and for those of you that don't know, that's the judge on the Richard Allen case that I always, like, held out this hope that she was gonna see things different, that she's gonna look from the other side. I do think when the defense says things to her like, "And I hope your honor is going to hold the prosecution to the same standard, to the same level of inquiry that you hold us to," and she says, "Oh, yes, I will." I hope that I'm gonna hold out hope that that is true, and we'll see how she handles that with these, motions in limine.
Okay, so I forget where I was. Knowing that the employees of ARCA were not hired by the Defense Council or Commonwealth and instead were hired at time they performed their testing by a neutral third party can and should add legitimacy to the credibility of these individuals' testimonies as the potential for bias or any other self-serving reason for the defense's calling of said witnesses would thereby be eliminated. Footnote 3. The Commonwealth is of course more than welcome to cross-examine these witnesses regarding its allegations of bias or favoritism. I mean, if you're the defense, you're praying that Brennan's stupid enough to do that. It forces the answer. It forces, we didn't even know. I'm going to restate what we've already stated on direct. We had no idea anything about this case other than we were given in terms of performing these tests. That's it. We didn't know who Karen Reed was. I didn't know who Jackson and Inetti were. Anything, anything. So, I mean, if Brennan's foolish enough to ask that question, go for it. This information about the hiring of ARCA employees, furthermore, could help the jury better evaluate the defense's theory of the case that Miss Reed could not have been and was not responsible for the death of Mr. O'Keefe. Essentially, by clarifying who initially identified, hired, retained, and directed the investigation and testing performed by the employees of ARCA, Miss Reed should be allowed to substantiate her lack of culpability by presenting evidence that an impartial third party vis-a-vis their findings corroborates her defense. That's it. It's my whole goddamn thing in a nutshell, right there in one sentence. In short, for the jury to properly weigh the credibility and accuracy of the ARCA employee's testimony, it must know the full context in which these potential witnesses were brought in to opine on this matter. For these reasons, it is imperative that the jury in this retrial is made aware that the employees of ARCA were initially hired by the U.S. Attorney's Office, eliminating any possibility that the jury believes that Miss Reed or any related affiliates were the impetus for ARCA's testing and analysis. Footnote 4. Throughout this motion, the defense is referring to the initial retention of ARCA by the DOJ for the purpose of conducting its testing analysis and producing a report. The defense again acknowledges that ARCA was paid after the conclusion of the first trial, as the defense disclosed in its reciprocal discovery production, and as was discussed extensively during motion hearings before this court on 3 separate occasions. All
And
right, you
they're
ready
they're
to?
pointing that out just because the judge seemed to act as though there was some relationship or some bias because of the fact that they were paid or because of some
Grave
of what
concerns. She
right,
had
some of what
grave
was
concerns. I have grave concerns. All right, you want to read 2?
sure. 2, the fact that the U.S. Attorney's Office retained retained employees of ARCA is relevant, admissible evidence. It is undisputed and relevant evidence that the U.S. Attorney's Office hired and was responsible for involving employees of ARCA in an investigation surrounding Mr. O'Keefe's death. The pertinent information that a neutral federal investigative body, as opposed to a defense or an affiliated third party, retained ARCA is clearly relevant and, beyond being relevant, is exculpatory evidence that is fundamental to Miss Reed's case. And they cite Massachusetts Rules of Evidence 401. According to the Massachusetts precedent, all relevant evidence is admissible unless barred by an exclusionary rule, citing a Massachusetts case. Additionally, the Massachusetts Supreme Judicial Court has long recognized that, quote, as a general proposition, a judge does not have discretion to exclude relevant evidence. Again, citing Massachusetts case law, including the concept that, quote, the general rule to be followed in this Commonwealth is that all relevant evidence is admissible unless with an exclusionary rule. And another case from 1973, we are influenced by the general view that relevant evidence should be admitted unless there is a quite satisfactory reason for excluding it. Relevant evidence may be excluded if this honorable court finds that the evidence's probative value is substantially outweighed by the danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. And that's Massachusetts Rule of Evidence 403. Acknowledging the objective fact that that employees of ARCA were hired by the U.S. Attorney's Office is relevant, probative, and would not confuse issues, mislead the jury, or otherwise cause an undue delay, waste time, or constitute cumulative evidence. And I would add in here, quite to the contrary, that the lack of this evidence is what has led to confuse and mislead the jury. Going back to the body of the motion, more pertinent to the narrow issue presented in this motion, the probative value of this evidence is certainly not substantially outweighed by any of the above. Relevant evidence by nature is inherently somewhat prejudicial. That is why it is offered. The rules of evidence have contemplated this fact and bar admission of evidence only if its probative value is substantially outweighed by the risk of unfair prejudice. Again, citing a Massachusetts appellate court case from 2013 for the concept that, quote, the measure of unfair prejudice is not whether the evidence simply is adverse to the party against whom it's offered. To find relevant evidence is unfairly prejudicial and thus inadmissible. Generally, the evidence must influence the jury to decide the case on an improper basis. More specifically, the evidence is unfairly prejudicial if it, quote, appeals to the jury's sympathies, arouses their sense of horror, provokes their instinct to punish, or otherwise may cause the jury to base their decision on something other than the established propositions in this case. And they cite to that same 2013 case. Moreover, in balancing the probative value of evidence against the risk of unfair prejudice, quote, the fact that evidence goes to a central issue in the case tips the balance in favor of admission. Here, the neutral third-party experts hired by the U.S. Attorney's Office corroborates Mrs. Reed's fundamental defense that Mr. O'Keefe's injuries are not consistent with being hit by her SUV, nor is the damage to her SUV consistent with colliding with Mr. O'Keefe, is inherently central and foundational to the fair adjudication of this case. Additionally, the Commonwealth has faced no unfair prejudice. The Commonwealth had the opportunity to cross-examine ARCCA experts during voir dire in Ms. Reed's trial, and notably, the Commonwealth is privy to the testimony of ARCCA employees in Ms. Reed's first trial. Additionally, the Commonwealth has access to the same discovery that the defense has received regarding these employees. Thus, there is no legitimate basis for the Commonwealth to even allege that providing information about the U.S. Attorney Office's hiring of ARCCA would be even remotely prejudicial. The defense acknowledges that this is an unusual circumstances and accordingly an unusual motion in an unusual case. Generally, witnesses who are employed by the federal government testify on behalf of the Commonwealth, and defense counsel is unaware of any case in which a defendant has moved to preclude reference to the federal employer of a witness testifying on behalf of the Commonwealth. This is what we were screaming about earlier. That happens all of the time. The state, the government, they get the benefit of the fact that these are police officers, these are federal agents, these are people hired by federal agents. That happens in every courtroom all over our country, literally every day. Moving on. It is not uncommon for the Commonwealth to present witnesses employed by the federal government, especially, though not exclusively, in matters that involve a joint investigation by state and federal authorities. And they cite a 1992 Massachusetts case discussing DNA testimony by a supervisory special agent and chemist for the FBI's DNA analysis unit during a motion hearing. They cite another case from 2010 discussing DEA agent testimony elicited by the Commonwealth, another one in 1983, finding that a reference to a prior arrest of a defendant and an FBI fingerprint analysis were not elicited in bad faith, and holding the defendant was not prejudiced by those references. Undersigned counsel is unaware of any case in which a defendant has successfully argued that eliciting the fact that a witness was employed or contracted by the federal government was improper, let alone caused her prejudice. Ms. Reed suggests that the preclusion of any reference to the party that had retained ARCCA during her first trial caused juror confusion and caused jurors to speculate about whom had hired the company, prejudicing her defense by reducing the import of the testimony and perhaps her two most critical expert witnesses. That is gospel. Gospel. Moving
Agreed. Agreed. Are you going to move on right now?
on.
Moving on.
Well, I thought you were going to say something and then you
Hey,
didn't.
listen, man. I just love that new addition to the show when you say moving on. It's good. Don't ever stop doing it.
Okay. Providing
Love
the
it.
jury providing the jury with information about the underlying nature of ARCCA's involvement surrounding Miss Reed's case, furthermore, would certainly not cause undue delay, waste time, or be cumulative of other evidence. Such information could and would be elicited with few questions during the direct examination of these potential witnesses. Potential? And by no means would asking the ARCCA employees by whom they were hired and retained stall trial proceedings in a wasteful or cumulative way. Questioning on this matter would be brief and could not be entered into evidence but through direct examination. Most importantly, perhaps this pertinent evidence would not confuse the jury. In fact, clarifying how ARCA employees became involved in the investigation surrounding Ms. Reed's case would only mitigate potential jury confusion, as discussed above. Relatedly, for example, in Ms. Reed's first trial, the defense asked during direct examination whether ARCA employees were hired by the defense or the Commonwealth, citing to the trial transcript. The testifying witness, Dr. Wolf and Dr. Rentschler, both answered in the negative because further specific questioning about how these ARCA employees became involved in the investigation surrounding Ms. Reed's case was not permitted, though the jury was left to speculate, theorizing erroneously that a third party, such as Ms. Reed's car insurance company, was responsible for involving ARCA in this matter. Such an inference by the jury, even if logical, is patently inaccurate. Moreover, the jury should not have to resort to filling in unclear gaps by hypothesizing about the relationship between ARCA and Miss Reed, as that allows for facts certainly not rooted in truth and in evidence to influence the jurors' perception of key witnesses. This speculation was not cured by the court's instruction to the jury during the first trial and is unlikely to be remedied by any instruction in Miss Reed's retrial. Footnote 5, they cite to the model jury instruction, function of the jury, what is evidence, credibility of witnesses. Picture in your mind that all of the evidence, testimony, exhibits, stipulations went into a box. That box is now closed. Your verdict must be based on what is in the box, together with any reasonable inferences you choose to draw from it. Here, those inferences were obviously not reasonable. Moving on. Simply providing the jury with accurate information about who involved the ARCA employees in this matter would eliminate juror confusion and, more importantly, would prevent jurors from speculating about what third party hired and retained these individuals.
Okay. All
And then,
gospel. All that's gospel. You
right.
know, like this, it's such a little thing, and it's such a huge thing in terms of the impact it has on this trial.
And I think we can just summarize Section 3. It's Miss Reed has a constitutional right to present exculpatory evidence, and they just go through and cite the law. They cite how this is exculpatory. Obviously, again, reiterating that O'Keefe didn't. The injuries were not caused by a collision by Miss Reed's SUV, and again, just citing law to talk about how the exclusion of this evidence would deny her the ability to present it, and that she's got her constitutional right to present this evidence. Then they close with, as a result, Ms. Reed should be permitted to provide the pertinent information regarding the circumstances of ARCA's involvement in the case, which led to their ultimate conclusion that Ms. Reed was not responsible for Mr. O'Keefe's death, because such information provided by a third party is crucial to bolstering her foundational defense that the police investigation in this matter was wholly inadequate and authorities failed to investigate alternative suspects.
Where'd you read that?
That's the last paragraph of Section 2.
Oh, wait, what?
I'm sorry, Section 3.
Oh, you skipped it.
I just summarized it. Yeah.
You pardoned me from having to read it all. Like, this is an important motion, but all right.
No, now you go.
I mean,
Actually,
no,
read
that's
all
all
of Section 3. It's only another page and a half, so go for it.
right. I mean, let's go. Let's go.
There's a lot of motions, but go.
But they're really not lengthy. You know what I mean? So 3, Ms. Reed has a constitutional right to present exculpatory evidence. I think it's important for the people to know what their constitutional rights in this country are. So the Commonwealth, in seeking to prevent the defense from eliciting that ARCA was initially hired by the U.S. Attorney's Office, seeks to deny Ms. Reed her most basic and fundamental constitutional right, the right to present a defense, as guaranteed by Article 12 of the Mass Stack of Rights. The fact that ARCA was hired to perform its testing and analysis by the U.S. Attorney's Office is manifestly exculpatory. And this witness testimony undermines the central conceit of the Commonwealth's case, i.e., that Miss Reed struck Mr. O'Keefe with her SUV. The Commonwealth cannot, in good faith, cite legal authority in support of its request for this honorable court to exclude exculpatory information about the hiring of the ARCCA employees. Perhaps the most exculpatory and critical defense witnesses in this case. I would argue, not perhaps, absolutely the most exculpatory and critical defense witnesses in this case. Dr. Wolf and Dr. Rensler specifically were hired by the U.S. Attorney's Office to conduct an independent inquiry into whether Mr. O'Keefe died because of a collision with Miss Reed's SUV. Resoundingly, these expert witnesses answered in the negative. Mr. O'Keefe neither died as a result of a collision with Miss Reed's SUV, nor did any damage to Miss Reed's car result from colliding with Mr. O'Keefe. This conclusion, made by a neutral, emphasis added, third party, not engaged by the defense to perform this testing, affirms Miss Reed's defense and could serve as the most reliable, relevant, and exculpatory evidence in her forthcoming trial. Exclusions of this evidence would materially prejudice Miss Reed's defense. See De Jesus v. Yogel. The substantial rights of a party are adversely affected when relevant evidence is erroneously excluded, although evidence can be excluded under Massachusetts law if there is a risk of unfair prejudice, which there is not, that substantially outweighs its probative value. Commonwealth v. Kindle. So here, however, any prejudicial effect runs entirely in the opposite direction. To exclude this pertinent evidence about the U.S. Attorney's hiring of ARCCA would result in the jury deliberating with needlessly incomplete information, Preach, Yannetti, preach.
Yes.
Miss Reed's likely most exculpatory witnesses. Quit saying likely, quit capitulating. God damn it. They're the most critical witnesses. Given that such individuals were hired without bias or undue influence by a third party as a part of a federal investigation, would only serve to invite jury confusion and cause unfair prejudice to the defense, contrary to the rules of evidence and fundamental constitutional principles of a defendant's right to present exculpatory witnesses. More specifically, the fact that a neutral third party substantiates Miss Reed's core defense and completely undermines the Commonwealth's theory of this case is inherently exculpatory. Considering Massachusetts precedent, it is permissible, particularly during closing argument, to disclose by whom an expert was retained. In fact, a plethora of Massachusetts and federal case law confirms as much. See Com v. Grimshaw. The fact that the expert witness was retained by the defense would have been an appropriate subject of argument to the jury. Citing Com versus O'Brien, the fact that Dr. Mezer was retained by the defense was an appropriate subject of argument to the jury. U.S. v. Cresta, the jury must be informed of the exact nature of the contingency agreement. The defense counsel must be permitted to cross-examine the witness about the agreement, and the jury must be specifically instructed to weigh the witness's testimony with care. Commonwealth v. Freeman, a prosecutor can address in closing argument a witness's demeanor, motive for testifying, and believability, provided that such remarks are based on the evidence or fair inferences drawn from it, and are not based on the prosecutor's personal beliefs. Hank Brennan. Hashtag just says shit. While a prosecutor may not vouch for the truthfulness of a witness's testimony, we consistently have held that where the credibility of a witness is an issue, counsel may argue from the evidence why a witness should be believed. In essence, there is a deeply rooted basis for both identifying the specific terms of the retention and hiring of an expert witness. And there is foundational support for commenting on why a witness's credibility and here neutrality should be trusted. Aw, hi, buddy.
Yeah, I take back not reading this this argument in full because it does flesh it out, and it
Well, give me
is
kisses.
so on point.
So on
So on point.
I mean, I was never not reading it, babe. I mean, you're the boss. Finally, Miss Reed's constitutional right to present exculpatory information includes asserting a Bowden defense. Both the Commonwealth or Bowden, both the Commonwealth and defense have long had access to ARCCA employees' findings regarding the death of Mr. O'Keefe, which resoundingly point to an inadequate investigation and a third-party culprit, given that ARCCA employees have testified under oath that Mr. O'Keefe's death was not as a result of injuries from Miss Reed's SUV. Since the Commonwealth had access to this information and did not properly inquire or investigate other potential suspects, Miss Reed must be able to present evidence that law enforcement failed to pursue other avenues. Commonwealth v. Bowden. Defendants have the right to base their defense on the failure of police adequately to investigate an unaliving in order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. A Bowden defense, as it has commonly come to be known, may focus on either the failure of the police to conduct certain scientific tests or, emphasis added in bold, their failure to investigate leads concerning suspects other than the defendant. The failure of the police to investigate leads concerning another suspect is sufficient grounds for a Bowden defense. As a result, Ms. Reed should be permitted to provide the pertinent information regarding the circumstances of ARCCA's involvement in the case, which led to their ultimate conclusion that Ms. Reed was not responsible for Mr. O'Keefe's death, because such information provided by a third party is crucial to bolstering her foundational defense that the police investigation in this matter was wholly inadequate and that the authorities failed to investigate alternative suspects. Conclusions for everything I just said. Do the right goddamn thing, Judge. Thank you. All right. That was a banger motion.
That's the one. That's the one. That is, like Bob said, the most important one.
It's the one. It's the one. For this case, it's the one. Okay. Talking about impounding. Motion for protective order. Okay, so this is the Commonwealth wanting a protective order restricting public dissemination of all communications to be provided to the defendant. This order is necessary to effectuate the well-established privacy and safety interests of the witness and the victim's family. Okay. Defendant's motion to eliminate to present demonstrative exhibit based on Christina Hanley's testimony.
Now, I'm not sure if we located Exhibit A, which
You had Tracy working on it.
yeah.
It
Let me look back.
seems
I might
to
have seen
me-
it.
Yeah, I don't know. Trace, did you ever find it? If she couldn't find it, it's not out there. You know what I'm saying?
Right.
All right. So why don't you go ahead and give us the factual background, or you want to read that and see if this is one you can just summarize the argument while I read the factual background.
I'm sorry, which motion is it?
This is related to the Commonwealth's witness that was up there talking about glass and where she thought
Oh,
the
yeah,
glass
yeah,
came
I
from.
reviewed that.
It's
Yeah, yeah,
another
yeah.
important one. It's another because they want to use a chalk. We don't use that term here. The chalk.
What does that even mean?
He'll explain it in here.
Okay.
See, we can learn something new today. Exciting. It's exciting and new.
I thought they were, like,
Come
actually using
aboard.
chalk to, like
We've been expecting you. All right. So, factual background. Miss Reed is accused of the following crimes rising out of the death of Officer John O'Keefe: unaliving in the second degree, manslaughter while under the influence of alcohol, and leaving the scene of personal injury and death in violation. So on January 22nd, or strike that, January 29th, 2022, Mr. O'Keefe is captured on video surveillance footage leaving Waterfall Bar and Grill with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in Mr. O'Keefe's possession at the time that he arrived at 34 Fairview and was broken in the early morning hours of January 29, 2022, outside the Albert residence after being struck by the taillight of Miss Reed's vehicle. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of 34 Fairview and the rear bumper of Miss Reed's vehicle. The source of the glass recovered from the bumper of Miss Reed's vehicle in the lawn of 34 Fairview is material and relevant to this case. At first trial, Christina Hanley, a forensic scientist at the MSP crime lab, testified for the Commonwealth about the pieces of glass recovered from the crime scene and from the bumper of Miss Reed's vehicle. Then they cite, looks like the transcript. This testimony lasted more than an hour and spanned 37 pages of the trial transcript. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview and the bumper of Miss Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. Some pieces of glass came from the same source, meaning they were originally a part of the same object. Ms. Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. During trial, Ms. Hanley herself frequently needed to refer to her notes and request that counsel repeat questions to keep the various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative aid consisting of one chart spanning 1 page, containing representations of all recovered pieces of glass and graphics depicting which pieces came from which glass or source of glass. The proposed chalk tracks directly with Ms. Hanley's testimony and report. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Each group of pieces is called an item. These items are 1, item -3.2 or 3-2, the base of the cup recovered from the scene. Number 2, item 3-3, 5 pieces of glass taken from the bumper of Miss Reed's car, viewed by the laboratory as 1 item. Number 3, items 7 through 12 or 7-12, 9 pieces of glass taken from the scene by Trooper Buchanan, viewed by the laboratory as 1 item. And 4, item 7-14, a single piece of glass taken from the scene by Trooper Proctor. Each smaller piece of glass within 3-3 and 7-12 has an additional lettered label referencing the individual piece itself within the border, quote, item. Item 3.3 contains the sublabels A, B, C, D, and E, each letter representing an individual piece of glass. These sublabels are the same as those assigned by Ms. Hanley in her testimony and in her lab report. These sublabels are the same as those assigned by Ms. Hadley in her testimony, in her lab report. Oh yeah, I just idded myself. Similarly, the 9 pieces of glass in item 7-12 are labeled A through L, skipping letters G through H, as was done in Ms. Hanley's testimony and in her report. For each individual piece of glass, the chart includes a graphic text next to the corresponding label based on which other pieces of that glass matched. The graphics in the column next to each label corresponded directly with Ms. Hanley's testimony, particularly the testimony on pages 75 and 76 and 90 through 92 of the June 5, 2024 trial transcript. Each sublabel has a graphic next to it, indicating which other pieces of glass it matches. Through these graphics, the chalk summarizes Ms. Hanley's conclusions into a simple chart. Love charts. Charts are awesome. Which Ms. Hanley confirmed was an accurate representation of her testimony. So did you I think this is one you can summarize.
I think there was actually some important things. So
Okay, it's all you.
All right. Um, so argument to assist the jury in visualizing Miss Hanley's granular and essential testimony, the defense proposes the attached demonstrative exhibit or quote chalk to aid the jury, which is attached here too as Exhibit A, although it was not actually attached. That just might be the way the judge wants things handled, um, as far as it being produced and not filed. A demonstrative exhibit is something presented to jury to help them follow and understand the evidence. They go on to describe how demonstrative exhibits can take different forms and aid the jury, and they're particularly useful when they present complicated testimony that may be difficult for a jury to understand or visualize. They cite a 2002 case that allowed a 34-page bar chart as a chalk to depict hours defendant billed to Medicaid for a particular period. Um, these sorts of aids are appropriate where they're relevant. They are not more prejudicial than probative, and and they sufficiently resemble the actual event so as to be fair and informative. Or they are a fair representation of the facts the chalk aims to clarify. Finally, the court has broad discretion in determining whether to admit a demonstrative aid. I'm surprised this requires such an extensive motion in limine. I don't know why they would not be allowed to use demonstrative evidence like this, but um, uh, Section 1, the proposed chalk is highly relevant. Ms. Hanley's testimony is clearly relevant, i.e., whether any glass on the bumper matches the cocktail glass at the scene or is from some different unidentified source, and goes directly to whether the evidence in this case supports that Miss Reed struck John O'Keefe or the cocktail glass in question, citing Massachusetts Rules of Evidence 401. The relationship between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Miss Hanley's testimony about this glass, is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would need to be able to either accurately record or memorize the source of each piece of glass and each piece's relationship to all the other pieces in order to make sense of Miss Hanley's testimony. The complexity of this testimony is underscored by Miss Hanley's frequent reference to her notes and requests for counsel to repeat questions, particularly questions about the relationship between those pieces of glass. And they cite to the transcript. Of course, referencing notes and requesting the repetition of a question is permissible and even preferable to ensure that testimony is accurate. However, if a lab tech has trouble keeping track of the labels of evidence that she analyzed herself, surely the jury would have more trouble making sense of this critical evidence, making the chalk not only relevant, but essential. Section 2, the chalk would not prejudice the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed by its probative value. This chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Miss Hanley's testimony, which otherwise requires jurors to memorize and differentiate the titles and various sources of pieces of glass with labels that closely resemble one another. It's a mere depiction of which glass pieces match others and visual representation of Miss Hanley's live testimony. Given the chalk corresponds so closely with Miss Hanley's testimony, a witness for the Commonwealth, it's difficult to see how the chalk could be remotely prejudicial. If the court finds there is some prejudicial tendency to the proposed chalk, it is far outweighed by the probative value. The Supreme Judicial Court in Massachusetts has been liberal in allowing demonstrations and chalks, even where there is a potential for extreme prejudice. In Commonwealth v. McGee, where the defendant was accused of unaliving his partner in front of their 6-year-old child, the Supreme Judicial Court of Massachusetts upheld the allowance of a physical demonstration by that child, then 10 years old, of the position in which he saw his mother on the couch when she was unalived. In support of this decision, the court highlighted that testimony about a decedent's position on the couch at the time of her unaliving was crucial in determining whether the premeditation element of Murder in the first degree was met. Given that a live demonstration by a child of the position of his mother, what of the position his mother was in when she was unalived, was permitted as more probative than prejudicial. This proposed chalk, which simply depicts Miss Hanley's testimony, is certainly more probative than prejudicial, if prejudicial at all. The proposed section 3, the proposed chalk directly mirrors Miss Hanley's testimony and fairly and accurately. Then they just sort of repeat that, the fact that this does fairly and accurately reflect her testimony. And in conclusion, they say without the chalk, Ms. Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence Ms. Hanley will present, given the great relevance of the context of the contents of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Ms. Hanley's testimony. The proposed chalk should be permitted. For the reasons above, Ms. Reed respectfully requests this court allow the attached chalk be presented to the jury.
Okay. So I think the real question is, we say chalk. I think over in Mass they say chalk.
Chalk.
The chalk.
Chalk.
We need a chalk. I remember the first time they were talking about that in the trial. I'm like, what is he saying?
Chalk.
Chalk. Chalk.
Cupcake invasion.
Where do you think that came from? I love cupcake invasions.
Oh, I was reading off screen. Oh, here come the cupcakes.
We love cupcakes.
Cupcakes are coming from Melanie Little, the cupcake invasion. This is so exciting. Hi, all of you. Cupcake raid.
Welcome, welcome, welcome. We love you guys so much.
Yes, we do. And any of our audience out there that has not already subscribed or what's it called?
A member.
Whatever, to attorney Melanie Little. She has followed the Karen Reed case from day one. Deep dives from everything from the pre-trial and the first trial to now.
And she is outraged.
She's definitely outraged. I'm so glad to have all of you cupcakes. I was looking off screen while I was reading. So
we truly are. And we apologize in advance if we're going through a lot of the same stuff, but it's always good to hear as many lawyers' thoughts on these things as possible.
And what you missed thus far is what we have been most outraged about and have declared to be of the utmost importance in this case is the motion to allow the ARCCA witnesses, for the jury to be told where the ARCCA witnesses came from, who they were hired by. That has got to go in favor of the defendant. And I'm sure you guys have heard all the rantings and legal support for that on your way over here. So
I mean, defense donuts is very coppy. Like, isn't the thing that cops love donuts? I mean, look, Allie and I we love a donut. We love a blueberry cake donut. Like, what we'll do?
No,
we'll
we don't want
buy,
defense
like,
donuts. We'll leave the pastries, the baked goods to attorney Melanie Little and let her have her cupcakes without our donuts.
I will say though that you and I do love a blueberry cake donut. Like, we'll always buy one. We'll get like
I love a blueberry
cake
cupcake. Yeah.
True. Right. Because you and I will pick at the one. We'll get one for each of us, and we'll just pick off little pieces of it over the course of a full day. So
all
cute.
right. So I'm gonna take part of it, maybe not take back, but this is also a very important motion.
All right, well, we're gonna read it.
I did not think there was a lot of so-called prior bad acts and propensity evidence that was just bullshit. So this motion by the defense is seeking to limit some of what the prosecution is allowed to bring out about, prior bad character and bad acts of Karen Reed.
All right, so let's get into it. And this is all dealing with the Aruba. The Aruba incidents. Okay, so now comes defendant Karen Reed and respectfully moves this honorable court in limine to exclude any references to the irrelevant, inadmissible, and prejudicial events that purportedly transpired in Aruba On December 31st of 2021, as grounds for this motion, the defendant states that the proffered evidence is not relevant to any material issue in this case. And that is Mass Rule of Evidence 402.
All right,
Should
so
the
now
court
I'm
Yes.
sorry, I've got a question because this is like we said before that I was wondering what happened pre-trial first time around, and maybe some of the cupcakes can answer in chat. Was this not did they not raise this same issue? I thought that they must have to try and say that this Aruba evidence didn't
Excuse
qualify
me. It's Aruba.
Aruba. Um,
How they say it. That's how they say it.
if did they make this very same argument the first time around and lose, or did they not make it? Um, and I'd be surprised if they didn't, because anytime that the Commonwealth or the state or the government wants to get in prior bad acts, things like that, it's there is some form of a motion in limine. It is discussed
Always.
ahead of time.
Always.
So, and I'm seeing that they did raise it and lost. Um, Canoni leaned on it shows state of relationship. So I wonder how there is something in the law called the rule of the case and or the law of the case doctrine, and that's where a court already decided an issue. You can't typically re-raise it and ask them to redecide it. Now that might change because there were facts that came out during the first trial that showed that this was not as relevant as she may have thought, that this was not as reliable or pertinent. So we'll keep rounding, we'll keep reviewing it. But thanks to our I'm assuming these are cupcakes. Maybe not all of you are who are answering this, but saying yes, denied. Here's a one of our members saying yes, denied. So,
They know.
um,
The cupcakes know. So, should the court find that the evidence is relevant, any potential probative value of the proffered evidence is outweighed by the substantial risk of unfair prejudice to Miss Reed, citing Oberly and Creighton. Factual background: Miss Reed is accused of the following crimes. Again, unaliving in the second degree, manslaughter while under the influence, and leaving the scene of personal injury and death in violation of. So the defense suspects that the Commonwealth will again seek to admit testimony regarding a completely irrelevant verbal argument between Miss Reed and a woman named Marietta Sullivan, which occurred in Aruba on December 31, 2021, for the sole purpose of trying to assassinate Miss Reed's character in the eyes of the jury. And that's exactly what they were trying to do with that.
I mean, no doubt about it. They're trying to show her as a jealous, controlling, emotional, overreacting woman.
Right.
And
So, and this all goes to the bullshit second degree unaliving. Like that's like it goes hand in hand with her angry voicemails and angry texts at John at 2 a.m. Like, where are you? The kids are here. What are you doing? Like any spouse or longtime girlfriend would be if they're gone, if their partner's gone and not returning calls, not returning texts, the irritation level rises. There is nothing untoward or unusual. And it certainly isn't an eye into the mind of Karen Reed and her desire to end John O'Keefe's life. What a flaming load of shit that was.
right.
So, at Miss Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Miss Reed and Mr. O'Keefe's relationship, and that the two of them were in good spirits on the night of January 28th, 2022. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding a verbal incident that occurred in Aruba 1 month prior, because between Miss Reed and a third party, which had no logical relationship to the crimes charged. None.
None. And that's as we see, it's what they're kind of leaning into here is like, look, you might have thought it was relevant. I'm just going to give you that, Judge Canoni, that it was relevant the first time around. But based on all the evidence that came out at the first trial, this is not relevant. This is prejudicial, and it is not appropriate to come in to lay
Highly prejudicial.
highly prejudicial.
The Commonwealth has no reliable evidence to suggest the Aruba incident had anything whatsoever to do with John O'Keefe's death a full month later on January 29, 2022, or that this remote and isolated incident was even a point of contention in Miss Reed and Mr. O'Keefe's relationship after that trip. At the first trial, the Commonwealth called Laura and Marietta Sullivan to testify about a highly inflammatory incident in which Miss Reed apparently got angry at another woman, not the decedent, because she purportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted this prior bad acts and character evidence for no reason other than to sully Miss Reed's character in the hopes that the jury would indict her based on the fact that she was, in Miss Marietta Sullivan's words, an asshole. At trial, Laura Sullivan admitted that she was not present during this verbal exchange between Marietta Sullivan and Miss Reed. So her testimony about the December 31, 2022 incident in Aruba is almost entirely compromised of inadmissible hearsay. Despite the court's limiting instructions about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Miss Reed crazy and that he had insinuated he was unhappy in their relationship.
I
Citing
also
the
don't understand why him being unhappy. I mean, it's just so ridiculous when you're dealing with a woman who, you know, they've got it sort of coming out of both sides of their ass cheeks in that, she's upset that he doesn't want to be with her, but she's talking to some other guy behind his back. She's got another place to live. She's got her own place to live. She's got her own money. She's got no reason or, you know, she's not bound to this man if she doesn't want to be with him. So now they're trying to argue, well, the fact that he was unhappy is somehow relevant. You're going to speak to his state of mind. You're going to you know speculate as to what he meant on one given day when he said a term. Highly prejudicial.
And they don't know Karen Reed from a hole in the ground, these two women. These are not buddies. They just happen to be in the same crew that went on the Aruba trip, period, end of conversation. That would be like us going on a big group trip with a bunch of couples, and like there were two random people that we had never met or barely had met, and like me giving some kind of deep analysis as to what that person is like in
Right.
order just to
Based
like,
on an offhand comment that may or may not have been actually made.
where's that coming from?
What?
Do you hear that?
No.
Oh, I got it running somewhere else. Hold, please. It's our music. I've got it running somewhere.
I
Where, I don't know.
we hear that you're
Unknown to me.
concerned about this.
Unknown. All right. So,
Well, you sound weird too, so figure it
I
out.
do? All
Yeah.
right, you keep reading. I'm gonna figure it out.
I can't scroll, but um
Hold on, I'll find it.
here I've got it up. So I'll keep reading even though he's not scrolling, but
Okay.
all right. So the last sentence in the factual is Marietta Sullivan's trial testimony was also extremely prejudicial to Miss Reed. Her retelling of the verbal dispute with Miss Reed was not probative of any material fact or element in the case, and it culminated with Marietta telling the jury decidedly that, quote, Miss Reed sucks. And she cites the trial transcript. As set forth herein, this evidence must be excluded. Under the argument section 1, the Aruba incident constitutes inadmissible prior bad acts and character evidence, and any potential relevance is outweighed by the risk of unfair prejudice to the defendant. And I wholeheartedly agree with that statement. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of evidence being offered, citing Massachusetts cases in 2013 and 2023. Quote, the purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted in evidence, and in granting such a motion, a judge has discretion similar to that which she has when deciding whether to admit or exclude evidence, citing numerous Massachusetts cases. It is a fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved, indictably or not, for the purposes of showing that his bad character or propensity to commit the crime charged. That they cite a Massachusetts case. That is black letter fundamental law, no matter what state you're in, or as it is in federal court. It's the type of evidence that has to be extremely limited. Although this type of evidence is sometimes admissible for other relevant purposes, such as to prove a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to unalive the victim, quote, such evidence should not be admitted if it relates to events which occurred at a time too remote from the unaliving. They cite an 1881 case which for the proposition that animosity between husband and wife, 3 years before the murder, too distant to be probative. They cite a 1959 case for the concept that evidence of a defendant's husband's adulterous relationship which terminated 7 months before a wife's death, not probative of motive for murder. Temporal remoteness is not an exercise in line drawing. Rather, a reviewing court focuses on the logical relationship between the prior bad act and the evidence at the crime and the crime charged.
Bingo, right there.
Exactly. That's what I was going to say. That right there says it all. And the last sentence there is, here, there is no such logical relationship.
None.
In order for evidence of a prior hostile relationship to be relevant to a defendant's motive to unalive the victim. And again, I'm just going to chime in here. That's exactly what we saw in the comments, people saying that is what the state is trying to get it in for. The evidence must actually establish a prior hostile and violent relationship between the victim and the defendant, citing a 2022 case, and that's Massachusetts High Court. Is that Supreme Court, their High Court, or what's their High Court?
Yeah, that is the Supreme Judicial Court is their High Court.
It is the Supreme Judicial Court. Okay. Prior and that case they cite for the concept that prior acts evidence included police testimony about a domestic dispute requiring law enforcement response and witness testimony about multiple physical disputes between the defendant and victim in order to show the, quote, nature of the relationship. And they cite a 2021 case for the evidence, including defendant's prior arrest for domestic violence, multiple restraining orders, and pending divorce proceedings, was admitted to show the nature of the relationship. Evidence of a defendant's prior threat to stab victim was introduced to show the nature of the relationship. A 2017 case, evidence including extreme physical violence, multiple emergency room trips, and threats to unalive the victim was admitted to demonstrate the nature of the relationship, as well as defendant's intent, motive, and absence of mistake.
See, those things all make sense. Those all make sense, especially if you're talking about a homicide case.
Right.
Not, I mean, those things all make sense. Not
whatever happened in Aruba.
Right, her being a little jealous, thinking that this chick was busting slob with her man, like that ain't it. That ain't it.
And like we just said, it goes right to that very last thing that they said here, that it has to have a logical relationship between that event and the crime charge, and there just is none here. They're just really, honestly, legitimately, you know, trying to be as even-handed as possible. It's not there. It's not there. I don't think anyone who thinks that she unalived him thinks that that was a planned thing having anything to do with what happened in Aruba.
No, it doesn't. And y'all, the 404B stuff that you see, not just in this trial, but every trial is always so important. And it's so like fervently fought, typically by the defense, because it's always the state or the Commonwealth that's trying to bring in some old shit that they're trying to show. We all know what they're saying. We know what the end goal is for the state
But
in
they
terms of why
squeeze it
they're
into one
bringing
of
it
these
in.
exceptions.
Yeah, they're trying to
For
squeeze it in,
bukkake,
and like it's
bukkake,
just
for bukkake, bukkake, for bukkake, bukkake.
Mandy, get off the mic. All right, keep going.
A 2016 case where the evidence, including extreme physical violence and threats with a firearm, was admitted to show nature of the relationship and motive. This case is not comparable to this incident. I'm sorry, this case law is not comparable to this incident, during which Miss Reed briefly became angry with another woman, not the decedent. That's hugely important here. Not the decedent,
Right.
because she believed that Mr. O'Keefe had kissed that woman. There was zero physical violence here, no threats of violence, no police involvement necessary, and absolutely no history of violence in Miss Reed and Mr. O'Keefe's relationship.
Beyond
I'm
that, Taryn
sorry.
felt terrible and like paid for half the woman's bill.
Right, right. Like, they are trying to paint her as a crazy woman,
Right,
just a crazy woman.
right.
So
Crazy
jealous,
jealous
so
woman.
emotional, so, all of these things. And you know what? Maybe she did still think that they kissed and she wasn't buying it fully, but she still let bygones be bygones and, you know, paid the woman's bill and, tried to say her apologies, whatever the case may be. It's just not relevant, and it is definitely more prejudicial than probative. The hope is here, and I honestly, I don't know that she being Judge Canoni is gonna make the right decision here, is that she will change her opinion from the first trial based on all of the other evidence that came into play, seeing now how, if this is probative, how minor the probative value is compared to the prejudice. And that's the scale. That's the balancing that is supposed to happen with these things. Is it probative? Okay, how probative is it? It's got like let's give them something. Let's give them like this tiny bit of probativeness. And when you take the prejudice, it's got to be, even-handedly here. I mean, it's just to me, there's not a question here. Um, I think I did miss the footnote, but I don't see it yet.
Footnote.
Wait, this is Oh, no, we're getting to it. All right. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant. And then in the footnote, they are discussing Rule 404B2, permitting the court to exclude evidence of a crime, wrong, or other act that is offered for a proper purpose, e.g., to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if the risk of unfair prejudice simply outweighs the probative value of the evidence. Going back to my little scaly thing I'm doing over here. This is a more exacting standard than the standard set forth in Section 403, which is to the rule that goes to excluding relevant evidence for prejudice, confusion, waste of time, or other reasons, which permits the court to exclude relevant evidence if the danger of unfair prejudice, confusion of the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence is substantially outweighs the probative value. Now, they're showing the difference here with 404B, that this is a a stricter standard. Compare Rule 403 with Rule 404B 2. That is because bad act and propensity evidence is, quote, inherently prejudicial, and the risk of improper use is enormous. And again, this is black letter law. And it goes right to that same argument that the defense was making to the judge with the bias, with the ARCCA. They're saying, look, well, we all know this is prejudicial. That's the whole point of it. It's prejudicial to the side it's being offered against. But you've got to weigh it. So moving on in the rest of this footnote, they cite to a 2017 case, say, and for the prospect that where offered to establish motive in prosecution for first-degree murder, quote, testimony regarding the change in the defendant once he began using drugs, including statement that the defendant had become a little more violent, was more prejudicial than probative. Again, there, because what's that statement worth? It's not worth all that much. It's not like police reports, a bunch of people. He had to someone had to go to the emergency room because he actually became violent. It's a statement like, well, the defendant had become a little more violent. Well, the court's saying, all right, well, when I weigh that on my prejudicial versus probative scale, it doesn't. It's so limited in probativeness that the prejudice outweighs it. So returning to the body of the case here, indeed, Massachusetts courts have long held that where evidence of prior bad acts is relevant for purposes such as intent or motive, it should be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. And that's what they're saying is the difference between 403, which is just relevant evidence, and 404B2 evidence. Here, testimony by Marietta Sullivan that Miss Reed became angry with Marietta, not the decedent, on December 31st, 2021, because she believed that Marietta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Miss Reed had intent to unalive John O'Keefe on January 29th of 2022. This event was remote in time and was clearly not an issue between O'Keefe and Miss Reed on the night in question, as evidenced by video surveillance footage from the Westfall Bar and Grill on the night in question and testimony of 8 witnesses, all of whom agreed that the couple appeared to be happy and in good spirits. There is no logical relationship between the Aruba incident and the crime charged. The Commonwealth's attempt to characterize this misunderstanding as some sort of turning point in Miss Reed and Mr. O'Keefe's relationship is off base and unsupported by the evidence. Now, I will just say that I don't believe everybody else's opinion that, like, oh, they were really happy that night and they all seemed really good. I don't think that really is very probative in and of itself, because we all know people put on airs when they're out with people. You never know what's going on behind the scenes. But I think the stronger argument is just how, if there's any probative value, it is so nominal compared to the prejudice. Especially,
One thing I could tell you for certain is that Karen Reed did not want to unalive John O'Keefe. Like,
I don't think anybody. Honestly, I don't
the
think.
state does. The Commonwealth thinks it.
I don't
They're
even know.
bringing
Does
the
anyone know?
goddamn
Is
charges
that
again.
what
They think it.
is that if we've got any people here who, and you're always allowed to freely, discuss your other side, but anyone who thinks that the evidence suggests that Karen Reed is guilty, is that because you believe she actually planned, wanted, and said, I'm going to unalive this son of a bitch and put her car in reverse for the purpose of striking and killing him? Does anyone actually think that's what happened? Because
The Commonwealth They think
Wow,
it. I
I
mean,
guess. Right. Well, that's what they're yeah, that's what they're saying. Um, okay, the sole purpose of the Commonwealth's attempt to admit this evidence is to sully Miss Reed's character by allowing Marietta Sullivan to testify that Miss Reed, quote, sucks. If we are able to believe the Commonwealth's best evidence, i.e., that Miss Reed said, go fuck yourself to
you're supposed to say
Marietta.
duck. You have
Sorry,
cupcakes in here.
I've got cupcakes in here. I should have said
Melanie's
duck.
very good at doing that.
Yes.
I wonder if when Mel's out, like, publicly, like, she just accidentally says duck all the time.
Well,
Like, like, in regular conversation. "Oh,
right,
duck
because she's
that.
used
Duck that."
that Miss Reed said, "Go duck yourself," to
There you go.
Marietta when she temporarily believed that she observed Marietta kissing her boyfriend on New Year's Eve in Aruba.
Aruber.
That evidence is simply not probative of a motive to unalive Mr. O'Keefe more than a month later when the parties were, by all accounts, in good spirits. In order for there to be a logical relationship between the prior bad acts evidence and the crime charged as required by Commonwealth v. Pino, a 2020 case, the jury would need to believe that Miss Reed reacted with a verbal "go duck yourself" when she believed she observed adulterous behavior on December 31st, 2021, but then subsequently flew into a murderous rage a month later when this event was remote in time and not subject of any argument on the night in question. That type of reasoning defies logic.
Those
Yes.
women weren't even there. Like, I could see the Commonwealth trying to make the argument that, that the Sullivan sisters showed up at the waterfall and were walking around and, shaking their stuff. And like John's over there. Look, I mean, none of that shit happened. Like, there's just like no connection, no connective tissue at all between what happened that night and what happened a month earlier. Nothing.
Right. Miss Reed,
Beta.
that's Judge Canoni. Uh, all right. That type of reasoning defies logic. Miss Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates that she knew the kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Miss Reed's character and prejudice the jury against her. Miss
True
Reed
story.
reasserts here that this evidence has no probative value regarding the crime for which she has been indicted. However, even if this court finds that the evidence is relevant, any marginal relevance of Miss Reed's temporary belief that O'Keefe kissed another woman on 1 month prior might have, in terms of evidencing a quote hostile relationship or intent to murder, is far outweighed by the prejudicial inflammatory effect it will have on the jury. I agree.
I agree. I agree as well. All right. So, Roman numeral 2, the Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. Moreover, mass courts have long held that the omission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would, quote, entirely eviscerate the rule's most important purpose of securing the correctness and completeness of testimony through cross-examination. Commonwealth v. Seabrooks. The Commonwealth's argument in prior proceedings that this testimony is admissible in order to show the defendant's state of mind is misguided. Again, the events in Aruba took place a month before John O'Keefe's death, and there is zero evidence to suggest that Miss Reed was still upset about it on the night of January 28th, 2022. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because this witness has nothing to testify about other than inadmissible hearsay and prejudicial character evidence. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness. She didn't see it. None of it. In Aruba on December 31, 2021, involving Miss Reed, Mr. Keefe, and her sister, Marietta. Laura Sullivan was also permitted to testify about her completely irrelevant negative impressions of Karen during the planning of the Aruba trip, i.e., that Karen told her she needed her own bathroom, maybe because she has Crohn's, and that she didn't want to share a room with John's kids. The Commonwealth then elicited additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. John O'Keefe told her that Karen is crazy during a later conversation on the night of December 31, 2021. And then on January 2nd, John insinuated that he was unhappy in their relationship. Notably,
Footnote 2.
Note 2, this unhappiness was allegedly communicated non-verbally and solely via Mr. O'Keefe's body language. Namely a shrug and an eye roll. Not only is this inadmissible hearsay, but it's an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation.
Yes,
It does.
And mind you, a lot of this is based on like these women's interpretation of Karen Reed and of her conduct is based on their misassumptions, like those wrongful assumptions, like she didn't want to be in the room with the kids, not knowing she needed to have a separate bathroom.
Right. They don't know her. I already said they don't know her from a hole in the ground. They have no idea about anything about this woman at all. To allow this testimony is outrageous. Notably, mass courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because, wait, did I read that already? I think I did. Maybe. Entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. Thus, all of Laura Sullivan's testimony regarding the Aruba trip constitutes prejudicial, inadmissible hearsay, which must be excluded. For all the reasons above, Ms. Reed respectfully requests this court do it. Do it. Keep that shit out.
And, you know, that's double hearsay. It's not even just hearsay because hearsay, anything that anyone said out of court. So even if, you know, if Officer O'Keefe wasn't the victim here and he was going to testify that he said she was crazy, that's hearsay. You're talking double hearsay. What he said, and not only what he said, but how he shrugged.
I mean, next thing we know, they're going to allow him to play Patsy Cline, like in the background for the entire trial. Crazy. I mean, come on. Let's go. All right, so let's see here. We've got wow. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they have taken the stand. All right, so what do you think? Moderately interesting?
Which one is it? Sorry.
Motion to prohibit the Commonwealth and its agents, namely the CAPAs, from speaking with or having contact with any witnesses once they've taken the stand.
Well, I mean, that should be the case. I just wondered if they put any facts in here that would be interesting about.
So they said, for example, cross-examination, Brian Albert indicated that he had spoken with Assistant DA Lally over lunch hour while the court was in recess during the middle of his testimony. That's
not allowed.
No, that's a no.
Not allowed. They should not need a motion in limine to be told not to violate the rules.
They're making the record, woman.
Yes, no, I agree. I'm just saying.
He initially denied speaking about the substance of his testimony, but then later admitted that Lally had discussed some of the topics he wanted to ask him on redirect. Quote, he may maybe mention one thing he may ask me. Just he was going to ask about what happened in the house in the morning. You know, some of the questions on redirect. That's all. Wow.
Not allowed.
Not allowed. Not allowed. I mean, not only not allowed, I've never had a judge not admonish the witness if there's a break being taken during the middle of either a direct or a cross, that witness is to talk to nobody about what's going on in that courtroom. Nothing about their testimony whatsoever. All right. So Ms. Reed states that the court has discretion to prohibit communications between witnesses and attorneys on third parties. In order to preserve the truth-seeking function of the trial, the court should prohibit agents of the Commonwealth from communicating with any witnesses once the witness has taken the stand. Yeah, no doubt. All right, so there's that one. That should be granted unequivocally.
Right.
Defendant's motion to impound, defendant's motion to eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment or intimidation of a witness. Okay, so that's a shorty.
And, the judge before her ruling was, well, if they
Somebody
bring it
brings up
up,
Aiden.
right.
I'm allowing it. I'll allow it. So defendant's motion in eliminate to exclude serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So this was interesting regarding the BAC.
Right. And there are good scientific and, reasons why this should be excluded. I was screaming that from the first trial. They have no actual reliable evidence of when she had her last drink. They
Right.
don't know if she drank afterwards. They know when they think she had her last drink. And there were also issues in the way that it was converted. So I think that those are all really strong issues. I how long is this motion?
It's a 9-pager. Like I'll just I'll breeze through it. Just
Do
hit some
the
highlights.
the factual background and then
So this is kind of the thrust of it. It says, since the Commonwealth cannot establish that the blood test result administered by Good Sam is reliable for purposes of a criminal prosecution, the serum plasma ethanol concentration result and the corresponding blood alcohol ethanol conversion and retrograde extrapolation, which derive their results from the initial result, should be excluded as unreliable and not the product of reliable principle and methods. So then they go through. So in addition to evaluating their hospital performed blood work and a urine drug test, which included tests for the presence of drugs and alcohol, Ms. Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Ms. Reed's blood of 93 milligrams /DL. So using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Miss Reed's blood, as would be normal course in a prosecution involving an aggravated form of operating under the influence, Mass Stades performed a conversion of the reported 93 megs, result to a blood ethanol concentration ranging from 0.078 to 0.083 based on 3 different conversion factors on May 4th, 2022. Using that conversion, Mr. Roberts then conducted a retrograde extrapolation on June 6th of 2022. In both reports, Mr. Roberts explicitly notes that the serum plasma ethanol concentration obtained from Good Sam, quote, was not performed at the Mass State Police Crime Lab, and therefore this report does not fall under the laboratory scope of accreditation. So after the first trial on September 17th, the Tox Unit Administrative Manual updated conversion factors used by Mass Stades Crime Lab to align with the ANSI ASB Best Practice Recommendation 122. So per a new report dated October 10 of 2024, authored by forensic scientist Hannah Knowles, the new serum plasma ethanol concentration estimated by Massachusetts State Police Crime Lab is now between 0.078 and 0.82, report by Hannah Knowles. Moreover, in Knowles' report, she uses a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45 a.m., the time of the alleged incident, in an attempt to, quote, account for the uncertainties associated with the drinking history of the subject prior to the time interval. Her calculations determined that Ms. Reed's BAC could have been between 0.14 and 0.28 at 04:45 hours, double 45 hours on 1/29 of 2022. This calculation assumes that the subject's BAC had peaked at or prior to the start of the interval time at 0:45 hours, indicating that the subject had consumed no ethanol, 0.5 to 1.5 prior to the time of interval. So
I mean,
then the
they
argument.
take the record here, and Little Cupcake pointed out that Crohn's disease can significantly disrupt digestion and metabolism, leading to malabsorption. Um, that might be part of what they they put forward here. But I mean, it's completely speculative. So I just don't know why the court would allow. I'm going to say it's, well, you can, these are all things you can point out. Uh-huh. The Nook's really going,
The
that you could
guy
point out
is bragging.
on cross-examination, and you can attack the testimony, but I do think there is a basis to exclude it. At the end of the day, I don't know that she's going to, exclude it here. Um, but it's the other thing is, when a hospital takes it, all of the medical records from a hospital, when they do it, they say this is not appropriate for use in a court of law. It's for medical only. That's why police go and they pull their own, or they do this calculation, extrapolation, but they need to know some facts that they don't know here. So, and I'm gonna grab my charger.
Yeah, I don't think she'll keep it out either, but she should. In terms of the defense, I mean, we know at this point, thanks to Ronnie, that they didn't even get her on the DUI. Like, they were not guilty on that. So, like, if I'm the defense, like, they obviously had to file this. I don't think they're overly concerned with it. There was the motion to impound defendants, motion to eliminate to exclude the witness's prior criminal history. Good cause exists for the impoundment of this motion and supporting exhibits. All right. To exclude. So I don't know which witness. I don't know which witness that was. Okay, so Eliza did a little quick affy here. She said good cause exists to impound defendant's motion and eliminate to exclude irrelevant, admissible, or prejudicial evidence regarding alleged harassment and or intimidation of the witness because it contains reference to grand jury proceedings. So that was what we'll call the Turtle Boy motion.
We wait. What was that?
I think that was
No, we read that already. That was the affidavit in their support of their motion to impound. Right. Just basically saying, I want to file this under seal.
Right. Commonwealth's motion to eliminate for sequestration order and for relief from that order for family members of the victim. So the Commonwealth further requested this court allow. So they want a sequestration of all witnesses expected to testify at trial, which I think makes sense. Commonwealth further requested this court allow the following potential witnesses to be accepted. So Paul O'Keefe, Aaron O'Keefe, so they can sit and stare at Karen right there, like the whole time. KF and nephew, PF, Peggy O'Keefe, William Reed, Janet Reed, and Nathan Reed.
Well, which one of those have testimony that deal with actual facts?
None of them really. I mean, Paul, not really.
Right. So then there's not a real issue with it.
Yeah, I mean, it looks like
who's
they're trying to exclude.
Oh, the victim's niece and nephew. Okay.
Yeah. So they're, because her dad, Karen's dad, was, definitely around the vehicle. I mean, he's got some factual type stuff he could testify to, but he's obviously the defendant's father. So we'll see what she rules on that. So Commonwealth's motion to eliminate or preclude reference to and redact the manner of death contained on the, what? He doesn't want that in. Commonwealth moves.
I think we looked at this before about that the first time, but yeah, let's read it.
So it just it's a shorty. It says Commonwealth moves eliminating in accord with settled practice that the death certificate be redacted for the means and manner of death. And then he cites a footnote down there. God bless America. Hold on. Why can't I make scrolling the default? I don't understand it on Adobe. It's super annoying. So in this case, the means and manner of death on the death certificate is undetermined. Yeah, I bet you don't want that in there, buddy.
She's still going to be able to testify to it, though.
Yeah, for sure. As now amended, provides that nothing contained in a record of a death, which has reference to the question of liability for causing the death shall it be admissible in evidence in a criminal trial, excluding from the death certificate the words homicide, suicide, and accident, or in this case, undetermined is a better and safer course, where the defendant does not dispute the validity of the death certificate or the fact that John O'Keefe is dead. The question of liability is left solely to the trial jury. And for the reason above, the Commonwealth asks this court to preclude any reference to and redact the manner of death contained in the victim's death certificate.
So
he's asking
so
for
any
the-
reference to,
Yeah.
and this is not, that is different. Suicide, homicide, and accident are different than undetermined. So that I believe that we looked into this the first time around and thought that absolutely positively she should be allowed to testify that it was undetermined. So we'll have to see what she does with that.
Okay, so here's the Commonwealth's motion. They're asking to use chalks too. Okay, they want to use computer assisted tech to display exhibits and diagrams or chalks. He doesn't specify specifically. The Commonwealth seeks to use the following: surveillance videos, photographs, videos from the crash reconstruction, videos from the reconstruction at One Meadows Ave, diagrams of the scene in the roadway, and diagrams of the digital forensic extraction reports. Yeah, like I want there to be uniform pictures of the house he used at this trial instead of like
Yeah.
the Commonwealth kept using pictures with no snow and shit. It was crazy.
Right. And they, if you remember, they tried to use that like reversing video as though they like tested something when it was just to test like um like the car in general. So, maybe having demonstrative evidence will help actually clarify that things are not exactly what happened and what the testing was. Because there was definitely some confusion. I can't think of what it was right now, but it was something about what actually took place when they were outside of the Sally port and they like put it in reverse. And it was like they were trying to make it seem like they were testing one thing when they really weren't. They were doing it for a completely other reason. So
Everything that
All right,
guy
so
just
this
said
is
bullshit.
exactly. You tell him, Vinny. Commonwealth's motion eliminate to admit the victims out of court statements relating to his state of mind. So the Commonwealth moves this honorable court to allow into evidence John O'Keefe's statements to his niece, nephew, family members, and friends regarding the defendant's intention to end his relationship with the defendant and statements about the tumultuous nature of the relationship, which are relevant to the victim's state of mind.
no, they're not relevant to the defendant's state of mind. And that's all that really matters unless she was aware of it. So let's
Right.
see what they're going to say here.
So he gives some law. The broad rule on hearsay evidence interdicts the admission of the statement made out of court, which is offered to prove the matter of what it is asserted or what it is asserted. However, declarations of out of court may be admissible to prove the state of mind or intent of a person when it is a material issue.
His state of mind is not a material issue. I'd like to see some. Let's see if they cite some cases here establishing why his state of mind. It could be, but not in this case.
Okay, so he says the state of mind exception to the hearsay rule calls for the admission of evidence of a murder victim's state of mind as proof of the defendant's motive to kill the victim when and only when there is evidence that the defendant was aware of that state of mind at the time the crime would be likely to respond to it. Commonwealth v. McGraw, Commonwealth v. Cruz, Commonwealth v. Hunter, and Commonwealth v. Zagransky. A murder victim's attitude or of contempt or hostility towards the defendant when it is known to the defendant, would constitute some evidence which, augmented by other evidence, might warrant a fact finder's determination the defendant responded by killing the victim. There need not be direct evidence that the defendant learned of the victim's state of mind, so long as, quote, the jury could have reasonably inferred that she did. Cite some more cases: Com v. Weichel, Com v. Franklin, Com v. Purcell. So where the jury were warranted in inferring that the defendant knew of the victim's state of mind, evidence of the victim's statement was inadmissible to show both the victim's state of mind and the defendant's motive to kill her. The Commonwealth intends to introduce statements the victim made to his family members and friends close in time to the murder about his relationship and with the defendant and his decision to terminate the relationship. Commonwealth also intends to introduce the victim's statements through text messages authored by the victim and contained within the victim's cell phone that express his decision communicated directly to the defendant to terminate the relationship.
So I'm just going to say right there, then there is no need for cumulative evidence about what he said to other people. If there's some sort of expression of that in a communication to her directly, why in the hell are they able to get in hearsay evidence about what he said to his family and friends?
Right. So the Commonwealth contends the victim's state of mind is relevant to the defendant's motive to kill him. The defendant and victim's relationship has deteriorated, and the defendant also made similar statements about the discord and disdain in their relationship. Disdain? Does he mean disdain?
I think
More
so.
typos, Brennan typos in their relationship, and the defendant herself had begun to engage in romantic and flirtatious communications with other men. Ooh, yeah, we all know about that. That sounds like, that was her revenge.
So in the 2017 case, they found adequate evidence for the jury to infer that the defendant was aware of the victim's plan to end the relationship without giving any facts as to how that was done. In a 1997 case, proper evidence of threats and discord in a relationship demonstrated respective states of mind of the victim and the defendant, again with no facts, no details there to say how that is comparable to what we have here. And in 1983 case, the defendant's statements and actions, including heated argument with victim in a week before the murder, permitted the inference that the defendant and the victim had communicated hostile intentions towards each other. That's very different. And then a 1976 case, defendant's statements to others concerning argument with the victim over their relationship, also very different, coupled with, read words like augmented by, coupled with the victim's willingness to tell third parties that her relationship with the defendant had deteriorated, permitted the inference that the defendant was made aware of the victim's state of mind. So also, I just think they're not factually on point. But go ahead, babe.
So whereas the defendant has repeatedly accused others of committing murder, the jury should be permitted to consider all evidence that demonstrates the relationship and hostility between the defendant and the victim at the time of the murder. Where the defendant described the murder as an accidental shooting, the pieces of evidence and victim statements, quote, considered together in the context of the location and manner of the victim's death, provided the jury with a sufficient foundation to reasonably infer that the victim made the defendant aware of her desire to end the relationship. The probative value of the victim's statements is relevant to the defendant's motive to kill him. The probative value of these statements outweighs any possible prejudicial effect, as the statements are being offered only to prove state of mind and not the truth of what was stated. Any potential prejudice could be remedied through a jury instruction on the limited use of state of mind evidence. So for all these reasons, I ask you to admit it. All right. Commonwealth's motion eliminate to allow an in-court ID. So,
What?
I'm trying to make sense of this one. So in Creighton, the court ruled that there was an eyewitness did not participate before trial and identification procedure, good reason for in court, blah, blah, blah. The court ruled that this rule also applies when an eyewitness to a crime has not made an unequivocal positive identification of the defendant before trial. While the court did not categorically circumscribe when the good reason might exist, the court provided the following two examples of good reason. One, when the eyewitness was already familiar with the defendant before the commission of the crime. And two, the witness is an arresting officer who was an eyewitness to the crime, and the identification would merely confirm the defendant is the person who was arrested for the charged crime.
Well, who is this?
I don't
Who is
know.
this
Let's
eyewitness?
get to it. Okay, so the circumstances here. Okay, so he says, while there are no eyewitnesses of the crime itself, witnesses observed the defendant close in time to the crime and in the subsequent aftermath and recovery of the victim's body. The circumstances here meet the good reason standard. As in
What?
Creighton, there was no out-of-court identification procedure conducted prior to the trial. Commonwealth intends to lay a foundation that the witnesses were familiar with the defendant prior to January 29, 2022, the date the defendant is alleged to have unalived John O'Keefe. The Commonwealth's witnesses include individuals who were friendly with the defendant and knew her through her relationship with the victim. This is not a case where a particular witness is identifying the defendant based solely upon his or her memory of witnessing the defendant around the time of the crime. As the court stated in Creighton, under these circumstances where the witnesses knew the defendant prior to the crime, there is little risk of misidentification arising from the court in a show up.
This
From
some
in
kind
court
of sick joke. So they just want an aha, like, moment where they're like, and do you see that woman in the courtroom?
Yes.
That is ridiculous. I mean, I don't think she's gonna prevent them from saying, did you go out to eat? Was she at the bar with you? And do you see that person in the courtroom? Yes, that's her there.
It's
I mean,
outrageous. It's
but
outrageous. It's
it's
crazy.
it's ridiculous. These aren't witnesses to the crime. None of these people are witnesses to the crime.
It's so transparently gross. Like, he's like, it's exactly what you said. He's like trying to get that aha moment with the jury. The pointing. Oh, yes, that's her wearing the fantastic pantsuit.
My gosh.
All right, so Commonwealth motion for offer of proof prior to defendant calling or summoning the Norfolk District Attorney and victim witness advocate as witnesses and request for an order that neither is subject to sequestration order.
So hell no, they better be subject to, unless she's decided they're not testifying, then they should be subject.
So they want an offer of proof prior to calling Morrissey or Stephen Nelson as witnesses for a finding that the DA and Nelson are not subject to any order of sequestration. So on March 6th, the defendant listed both Morrissey and Nelson as potential defense witnesses. When a defendant resorts to, quote, extraordinary means of calling a prosecutor as a witness, he must make a satisfactory offer of proof as to
That's
the
true.
need for the testimony from the prosecutor.
That's true.
That is true. Okay, so generally witnesses have the burden of showing why the subpoena should not be enforced. Prosecutors should only be called where there is a showing that the prosecutor's testimony is relevant, material, and not cumulative. Defendant failed to show the prosecutor had personal knowledge of relevant factors bearing on officer credibility that could not be elicited by other means.
And that's
same principles hold true for the advocate.
Right, and that's in a case that they were citing. And here's another case from 2001 where the victim witness advocate, you scrolled up too far, Bob.
Oh, what?
Now you've.
Are you reading?
Down. Yes.
Oh. Okay.
Go back down.
Oh, I'm all the way at the top.
I mean, up, I guess. Right there at the top of the page. Jesus.
Okay. All right. Okay.
A 2001 case where the victim witness advocate is a member of the prosecution team and notes discoverable or protected by work product rule to the same extent as prosecutor notes. I don't know if that there's any indication. Does anyone know what he's talking about? Are there notes, or is it just calling them?
I don't know. That's why I was trying to scroll down to see if this thing, like, if he gets
It does.
to it.
He's got some facts in there. Just read it.
Well, this is just talking about what like a victim's advocate does.
No, okay.
Where it talks about Morrissey's background, the elected DA. That Nelson's an employee as a victim's advocate. What they do, they provide victims and witnesses and family members needed assistance.
Right.
So neither the DA nor the advocate were recipient witnesses to the charges before this court. To the extent the defendant may want to impeach proposed Commonwealth witnesses as to statements, the defendant has not shown the absence of alternate sources of said purported information. So further, to the extent the defendant is seeking either the district attorney or the advocate's opinions or observations regarding witnesses' mental impressions, research, or evaluation of the evidence, or for the Norfolk County case, such areas of inquiry reflect privileged work product. So that's that. So that's like,
They'll have to give her some reason with that.
yeah, I mean,
They're
he has
calling
no
them.
idea at this point why they're listed. Commonwealth's motion to eliminate of intent to obtain Corey records of potential jurors. Okay. So he's just letting them know he's gonna get these Corey records.
I mean, she's gonna allow them? Let's see. So inquiring into I wanna see when they allow that because it's not every case that they're allowed to get Corey records, and if they do, they have to share them. The defense has to have the same access to information. So I wanna see if they're inquiring into the criminal records of a juror in a criminal case for the purposes of determining their qualifications to serve, that impartiality fits squarely within the criminal justice duties of a prosecutor and is permitted by the Corey statute. The Commonwealth is allowed to inquire into the criminal histories of jurors. A juror who purposely conceals their criminal history can be found impartial, to be impartial and able to follow the court's instruction. They said a case where, despite a lengthy voir dire that focused largely on jurors' attitudes towards law enforcement, the jurors' silence about criminal histories was found to be purposeful. Scroll down. Before the jury is sworn, the Commonwealth intends to check the criminal history of 16 prospective jurors. Of a one, wait, what does that say? Of all 16 prospective jurors. The Commonwealth's right to examine a juror's criminal records is not a radical one. If the prosecutor checks, which ordinarily should be done at the start of trial, the information must be immediately shared with the defense. Okay. But then they note that judges encourage to exercise discretion to order Corey records of selected jurors before they are sworn, where the procedure did not unduly burdensome or time consuming. So we'll have to see. I mean, I feel like this judge really is big on like protecting the privacy of people. So, if she lets him do it, she lets him do it. And the important part is that the defense has to have access to all that. It has to be immediately turned over, which he recognized.
All right, so this is motion to eliminate to appoint court stenographer, prevent identification of jurors and impound jurors' names. Not going to read that one.
No, and that's fair. We want to protect the jurors. We don't want their names getting out. We don't want their anything getting out.
All right, so here, Commonwealth's motion to eliminate to allow expert celebrate demonstration. So here, read through that one.
The Commonwealth provides notice that it intends to call digital forensic examiners Jessica Hyde and Ian Whiffen as expert witnesses in its case in chief. The Commonwealth respectfully requests that during Mr. Whiffen's expert testimony, the court allow him to conduct a courtroom demonstration of how data was stored within Jennifer McCabe's cell phone. Mr. Whiffen is the senior digital intelligence expert for Celebrate. Celebrate is a leading forensic extracting tool, blah, 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 blah. Jessica Hyde wants to do a courtroom demonstration to show jurors information and data on both Jennifer McCabe's and John O'Keefe's phone to explain concepts and to illustrate particular information of importance about how each respective phone's data. Now, I want to note here, they're going to show us the spontaneous deletion. That's what I'd like to see.
Spontaneous deletion.
Well, she give me an in-court demonstration of a spontaneous deletion. Jennifer McCabe provided her cell phone to law enforcement in the days following O'Keefe's death. Celebrate was used. Mr. Whiffen's an expert to provided to the defendant in 2023 his report. And Mr. Whiffen utilized his superior knowledge. Celebrate software to demonstrate how, where, and when Jennifer McCabe's Google searches were stored within the digital databases. The Commonwealth moves to permit him to conduct a demonstration using the Celebrate software. And then they just go on to say it's within the judge's discretion.
And that read that there.
The Commonwealth intends to have Mr. Whiffen use his highly disputed extraction report from Jennifer McCabe's cell phone to demonstrate with Celebrate software how, where, and when the digital data of the Google searches were stored. This demonstration would closely mirror the actual Google searches conducted by Jennifer McCabe. Bullshit. They do not know. They cannot explain the spontaneous deletion. There's a lot of speculation in that. But anyway, this demonstration would closely mirror the actual Google searches conducted by Jennifer McCabe on January 29,
No
2022,
way.
and would
No
aid
way.
the jury in understanding how Mr. Whiffen is able to opine that the contested searches occurred at approximately 6:24 a.m. and not
No fucking
2:27
way.
a.m.
They can't. She can't allow this. They're going to allow this guy who has what did he call it? What did he call it?
Superior knowledge.
His superior knowledge to figure out a way to make it look like she didn't delete that goddamn text in his demonstration. Not a chance.
Which he
No
could
way.
not explain the spontaneous deletion.
No way. All right, enough of that
Wait,
one.
scroll down. I just want to see the last part.
It's hot garbage.
In addition, both Mr. Whiffen and Miss Hyde would use demonstrations to articulate and explain important data information contained in McCabe's and O'Keefe's phones. I mean, I guess she's going to need some more details about this. The use of Celebrate demonstrations by expert who is a senior digital examiner for Celebrate would serve the essential truth-seeking function.
No way, Brennan. Blow it out your ass. That's crazy. All right, so this is their motion to admit the conversion stuff. Pass, hard pass on that. Commonwealth's motion for attorney conducted an individual voir dire of potential jurors. All right, so here he's asking for some individual voir dire in all cases to determine whether a juror has an impediment concerning hearing language or visual ability, mental health, or comprehension.
That's it? Those are the only things, not about the case itself?
Address any private or embarrassing information not disclosed in public portions of voir dire. Identify any other impediment to jury service.
All right. So, I mean,
that's what the
Commonwealth is asking.
Right.
So, a lot of times, sometimes it can actually prejudice the whole jury if one juror just speaks out about, well, I'll use a pro prosecution thing, or a pro defense thing. Well, I know that I've heard all about these corrupt cops planting evidence all over the place. You can see how that kind of thing said by the jurors in front of all the others, is an issue. And obviously when they want to ask, get deep into their background and their any mental health issues.
This one.
All right, that they don't want the jurors to have to do that in front of each other.
Here it is. It's the Delphi. It's the Delphi motion. So this is the motion eliminated to preclude the defendant from raising a third-party culprit defense.
Wow.
So the defense position has chronically been fluid and unsubstantiated. The defense claim has been nebulous from its origin. Karen, just to be clear, you didn't do it. We know who did it, Steve. We know, and we know who spearheaded this cover up. You all know that's a YouTube. I don't know.
Is that Aiden?
It's probably. After the first trial, the defense position began transformation. We're going to retool everything, and maybe some things will stay, some more, but we're going to shuffle a lot of things around. And then he's got another site to another YouTube. Somebody put those. Let us know in the chat. Are those Aiden's things? So most recently, in its Fox 25 sit down, the defense responded to the question, in your opinion, have there been a few names that have surfaced in third-party culpability theory? Who do you think, if John was beaten up and attacked in the house, who did it? Defense counsel uttered, we don't know. The defendant quickly echoed, we don't know. Counsel further, and it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John. But who was it specifically? Others know, and they're not talking.
It's not the defense's job to identify the exact culprit. If they've got enough evidence to point to someone who has enough of a connection, means, opportunity, whatever the case may be, they can put forth multiple possibilities. And I have said all along that they should leave this in the hands of the jurors to also come up with their own possibilities and to argue in closing. If you, as you sit back there, are talking about other possible scenarios that you believe to be reasonable possible scenarios of someone else or how else it could have happened or what else it might be, there's your reasonable doubt. I don't need to give it to
Yeah,
you.
this is bullshit burden shifting. The defense has we don't have to solve the crime in order to bring a third party culprit defense. People need to understand that. We don't have to solve the crime. Despite what old Judge Gull over in Delphi thinks, we have no obligation to solve the crime. If there's a nexus between those people and the crime, it's in. That's all there is to it. We don't have to solve shit. We don't have a burden. This thing, like,
But go ahead.
oh boy, Hank. The evolving responses have vacillated from an unidentified certain villain. This guy, I can hear him. When I read it, I hear his annoying voice speaking it. Do you guys? Can you hear when you're reading the words Hank saying this shit? From an unidentified certain villain to not knowing who is responsible and have been the hallmark of the defense's third-party culprit claims since its inception. The defense is not entitled to simply engaged in scorched earth. They're not. Brennan, he was supposed to be going in that house. He was getting dropped off to go into that house. How was that scorched earth? He was found dead on their lawn. How is that scorched earth? I've never heard of a situation wherein if they found somebody dead on our front lawn, babe, do you think they'd want to come into our house
Pretty
and peek
sure.
around a bit? Now, I would tell them to pound sand because I know my rights, but they would certainly ask.
Right. And then come back with a warrant since it was the last place they were known to be, where they were supposed to be, and then where their body was found. So
the defense is not entitled to simply engage in scorched earth tactics, making baseless and incendiary claims about witnesses without any evidentiary foundation. I just gave you foundation there, Brennan. Prior to the first trial, the court made rulings relative to the defense's third-party culprit claims. The court ordered, based on the offer of proof on Friday, I'm well within my rights pursuant to the case law to exclude the third-party culprit defense. I'm not going to do that now. I'm going to give you a chance to develop it through relevant, competent, admissible evidence, but you cannot open on it. That is my ruling on that. And then footnote 3, another YouTube.
that's to the trial.
So despite the court's clear ruling, the defense launched into its third-party claims from the beginning of its opening statement. Karen Reed was framed. It's true.
That is not a third, but that is not a third party.
Right. He's just
that is, he can say Karen Reed was framed. That's not third party culprit.
That's
Her
right.
car never struck John O'Keefe. That's not third party culprit. She did not cause his death. This is not third party. Come on, Brennan, pull your head out of your ass.
That means somebody else did it.
Well, it doesn't say who that person was. So.
So because the Alberts were involved and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. The evidence identifying or establishing a third-party culprit was never forthcoming throughout the trial, and to this day continues to be non-existent. So this is from Mass Guide to Evidence. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, or opportunity to commit the crimes is admissible, provided the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise inadmissible, the court must also find there are substantial connecting links between the crime charged and a third party, or between the crime charge and another crime that could not have been committed by the defendant. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third-party culprit. Somebody in the house. That's it. That's all they need for the victim's death, or any evidence of alternate circumstances that would have caused the victim's death. Bullshit. What is he talking about?
Right.
The absence of an evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. To accept the third-party culprit defense, the court would have to find the defendant demonstrated the acts of the other person are so closely connected in point in time and method of operation as to cast doubt upon the identification of the defendant as a person who committed a crime. I think they did. There's enough there. Again, they don't have to prove the crime. The
They
evidence
still have
must have,
Foden about failures to investigate anyway, but
yeah,
go
for
on.
sure. So the evidence must have a rational tendency to prove the issue raised and cannot be too remote or speculative. Therefore, the defendant would have to provide evidence of substantial probative value that another individual had the motive, intent, and opportunity to commit not only the homicide, but vehicular manslaughter and leaving the scene. Oh, so now he's conflating the two.
Okay.
So now he's sticking to, like, look,
You've got to prove my theory of how he was
right?
killed.
You
You've
have
got to prove that somebody else was in a car that hit him.
yeah, or that they got into Karen's ride and ran him over. So to raise a third-party culpable defense to one charge that is closely intertwined with the other charges would pose a real threat of prejudice by confusing jurors and diverting their attention to wholly collateral matters involving persons not on trial. So then he cites some cases. The defendant's right to a third-party culprit defense is not absolute, and the admission of a feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth because it inevitably diverts the juror's attention away from the defendant on trial and onto the third-party culprit, and essentially requires the Commonwealth to prove beyond a reasonable doubt that the third-party culprit did not commit the crime. So additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit and not within a hearsay exception may be admitted only if the judge's discretion, the evidence is relevant and will not tend to prejudice or confuse the jury. And there are other substantial connecting links to the
Why
crime.
do we have someone here now all of a sudden that's saying that somebody admitted to being the killer?
No, he cites some cases, which I'm not going to read. The court has the discretion to rule in advance of trial whether the defendant has made an adequate showing. Okay, so the arguments previously set forth by the defendant in pretrial motions contain only vague inferences, rank speculation, and scant detail of who, if anyone, had the motive and intent and opportunity to kill the victim. Third-party culprit is simply a defense tactic, unjustly prejudice the Commonwealth and to confuse the jury. The trial tactic is like any other, limited by the fundamental principle that the evidence must be relevant. If the defense offers its own theory of the case beyond merely putting the government to its proof, its evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. For the foregoing reasons, they should be precluded from alleging that any other individual is culpable for the victim's death. All right. So
their argument is that it's a speculative claim. However, all of their evidence that vehicle hit Officer John O'Keefe is pure speculation. It's pure speculation.
yeah. All right. So I'm calling it there because I got
All right, we've got to answer some questions and thanks.
We
some
do.
people.
We
So
do. All right, let's whip through them because we love you all and we are super, super thankful.
Thank you very much, Grin for me. As defense lawyers, have you ever felt like a TUI or internal investigation has stalled until they see if someone like Reed can just be found guilty and take the fall? Just seems more convenient. I mean, it's very unusual that there is like a separate investigation, parallel investigation going on to any of the underlying facts. So it's not something that you see every day anyway, but your point is very well taken. It does seem more convenient. Melissa, thank you for your generosity. Yeah, so I answered this with to do an interlocutory appeal, at least under what the rule that you cited there. Grin for me, thanks again. And Bob is a better cook.
True.
Except at
For
breakfast.
Breakfast, Allie is the best egg cook.
And your grandmother's meatballs.
And my grandmother's meatballs. Your last batch.
J Beans, thanks for your generosity. Learned about a special chart from all that tech wizardry. Thanks again. Scarlett would say dad. Uncle Fredo, thank you. The job of a prosecution to help the jury get to the truth, not kneecap the defense for a conviction. And exactly, that's what is happening here. And that's what Judge Cannoni's ruling about ARCCA is doing here. What about the truth? Programmer, thank you for becoming a member. Thank you for
Gamer.
your generosity. Pro gamer.
Gamer.
Couch Drawer, thanks for your generosity. Love Bob's emphasis on these darn things. I wouldn't let me
Wouldn't let
say.
him say filing. It probably pulled up that YouTube was saying it was something.
Oh, thank
Welcome.
you. Welcome,
Family
Ryan.
hug. Welcome, Ryan S.
Thanks for your generosity. Just a girl has been
From
waiting
Fall
for this.
River. I've been waiting for this.
Thank
you for
you,
your generosity.
History and Homicide, for your generosity.
Welcome to the fam.
Tom CPU, thank you guys for taking the time to delve into this. Thanks for your generosity.
Thank you,
More Melissa gifting memberships. Thank you so much. People are trying to get things for D, so their defense, so we could have something like cupcakes. Oops.
All right, I'm gonna whip through them. You're going too slow. My live's starting in 5 minutes. Aruba, Slutty Sullivan Sisters. Thank you. The Slutty Sullivan Sisters. Thanks, Subeka. We appreciate you and your generosity. Babe.
Sorry.
Babe.
All right.
Glamous's. They were trying to show it's like a battle when we try to put the comments up, or is that Mandy being evil?
Right.
They're trying to show her as calculating after John's death, yet a raging Viagra because John went to a house party. Nope.
Right. It's ridiculous.
100%.
Thanks for your generosity.
Crack in studio. Thank you. Cupcakes, welcome. Heavy welcome. We love you guys over here. And we love Mel. Thank you for your generosity. I was always cracking. Hot Water Boy, I was subbed. Now. Was gifted a membership. 40 minutes from you guys. Chicago guys are great. Free Karen Reed. Thank you, Hot Water Boy. We appreciate you. Larissa with a huge bomb.
Thank you for your generosity.
Have you and Allie ever been to the Lake Geneva? I answered this in the chat. Yes, many times. We love Lake Geneva. My aunt has a house there and love that place. Need to get a laugh today. Thanks for hanging with us.
My daughter was hoping to get married there, but everything booked up really quick. Oh, wait, not Lake Geneva. I'm thinking of, or is that, but go on. Never mind.
Okay. Bev's Belly Rumbles diary entry today. I had a bunch of cupcakes.
Thanks for your generosity.
That's adorable. And thank you. Thank you for your Canadian dollars. Sinead, member for 8 months. Shit. Family hug. We love you.
Got you on.
Glamous's, no member.
Thanks for your generosity.
Thank you. Afton, always thank you. Always giver, always mod. Love you. Long time. Kelly, question, is the judge allowed to do their own research on a case they're presiding over? Are they legally allowed to watch or listen to information regarding the case?
I mean, yes and no. I think that they, like watching what the lawyers or the people are saying outside of court to make sure that the judge thinks that they're following the rules, that is okay. They're not allowed to independently investigate like the underlying offense or the witnesses or the crime, things like that.
Bubba Hodge, family hug. Welcome to the fam. Thank you. We appreciate you so much. Beautiful. And by the way, Allie and I are talking about all the things we're going to start doing for our members only. So that's coming. I promise.
We're going to put something out to ask you guys what you want for members and Patreons.
I did that in community post last night. So
all right.
Please, anything that you guys have for Rex of what you'd like to see us do special for our members, let us know because we want to give you the love. Beautiful messy ball. Thank you for being a member for 4 months. Do you think the jury should be sequestered? Yes, I do. Glamous's, here's a tidbit. Higgy and Albert stated that Nelson said it was okay to destroy their phones the day before the order. True story.
Oh, so that's why they're trying to call Nelson to the stand. Higgy and Albert stated
and reminding us because I forgot that as well. Leslie's Google search, not $5 holla. The advocate was in the meeting before the phones were rehomed. True story. Thank you for that and your generosity. Julie Q, member for 1 month. Brennan is Ozempic Morrissey. Funny. Thank you for being a member, Julio. We love you. Josh H. So house long to die and Higgins destroying his phone isn't evidence of possible third party. It's not the defense's job to name who said third party is. Here. Correct. Thank you, Josh. We appreciate you. GV, me looking at Hank. I hate that man. I truly do. Thank you for your generosity. Lola, the good dog. Wish defense had motion to keep out any inference that John O'Keefe was hit by a car since it was proven he was not.
Right.
Excellent point.
It's like
Excellent point.
it's exactly.
Put that in
Exactly.
your pencil, Hanky.
Yes, Lola.
Lindsay Bay, member for 8 months. Aw,
Thanks for your
family hug. Thanks
generosity.
for bringing the heat. Thank you for being a member and supporting the show. We really, really appreciate you. Ipsy Dixit, Sherilyn, member for 1 month. Aw.
Yep,
family
because
hug.
Brennan
Study
said
celebrates
so.
his
Because Brennan
sisters.
said so. They've got to prove that somebody else hit him with a car. That's what, and maybe her car.
100%. 100%. All right. I got to run. I got another live with Tony Bruschi. I'm going to probably let Allie off the hook so she can feed our kids.
Yeah.
We love you guys so much. To our mods. Thank you so much. If your cupcake's coming over for Mel, we love you. We love Melanie. Think about giving us a sub. We think we give you good content. We think that you'll enjoy it. Give us a shot if you haven't. If you're here and you dug it, give a like on the way out. Let other people know we exist. We're trying to grow the show. You guys are so important for making that happen for us. It's an easy thing to do. Make sure you share, subscribe, and comment on replay if you have to. And always like on the way out. We love you guys. Thank you so much for hanging. If you don't have anything going on, I've got you automatically portaled to the one and only Tony Bruschi of Hidden Killers podcast. He's awesome. If you don't know who he is, he knows a little bit about everything, about every case going on out there. So it'll be great. You guys are the best in the business. We love you because without you, I'm just an old man
Sitting around talking to his wife.
Yep. Bye.